persons having business with the Appellate Division draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon. This is an historic day at the Appellate Division First Department, as it is the first sitting for Justice Margaret Ann Puyi Chan, who was recently appointed to our court. I worked with Justice Chan for several years in Supreme Court in New York County, where she joins us from the Commercial Division, and I know that she will be an excellent addition to our bench. She is the first Asian American woman to be appointed to the Appellate Division First Department. She was also born in Hong Kong and is the first female judge of Asian heritage born overseas who has served in this state's court system. Our court is strengthened by its diversity in gender, ethnicity, race, sexual preference, and professional background. Justice Chan has had a wonderful career as a judge, as a law clerk, and as an attorney working in immigration law. She's also given back to the profession. Her professional and civic activities are really too long for me to list here. However, she has been an adjunct professor at Fordham Law School. She's been on the PJI committee. She has served as the chair of the Law Department Committee at the Supreme Court. That's just a few things that she's done. So please join me in giving some applause to Margaret Chan.
Thank you very much, and thank you, Judge Moulton, for your kind words.
All right, we'll begin with today's calendar. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them and you'll have an opportunity to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you are requesting. People versus Jaden Decabert. Submitted. CJS Industries versus Dolce.
For respondents, 10 minutes.
5 and 2 and 4. Pamela versus Tayebi is submitted. People versus Juanes. Who are you here for, counsel?
I represent the respondent.
Would you like to be heard?
I'm happy to submit.
Very well.
Thank you.
People versus Claudio Rivera.
Calendar request 5 minutes on direct, 2 in rebuttal.
Respondent request 4, Your Honor.
4 and 2 and 4. .302 West 87th v. SHS. Five and 2 and 5. Gates v. NYU.
Appellant request 6 and 3.
Respondents are requesting
3? I'll give you 5 and 2 and 3. Severini v. New York City Department of Environmental Protection.
for the appellant Severini, 5 and 2.
Respondent 4.
4 and 2 and 4. People versus Walter Shike. Very well, on submission. Deutsche Bank versus March.
Good afternoon, Robert Huskell from Cape Westbury, Conway, for the respondent, 5 minutes.
Counsel, you didn't ask for any time on your initial brief, is that correct? Correct, Your Honor. All right, I'll give you 4 and 2. And counsel, you wanted 5?
Yes, please.
4 and 2 and 5. You want to remember to do that next time, though, counsel.
Yes, Your Honor.
Southern Israel versus Orgenesis.
For appellant, 5 and 2, please, Your Honor.
Respondent, 5.
5 and 2 and 5. Nicole versus Monique is submitted. People versus Umar Ali.
Appellant requests 3 and 1.
And for responding, Your Honor, 3.
3 and 1 and 3. People versus Robin Rosser.
Appellant requests 5 and 1.
Respondent requests 5.
5 and 1 and 5. Municipal Credit Union versus Thomas.
Good afternoon, for the appellant, 6 and 3, please, Your Honor.
For the respondent, 5 minutes, Your Honor.
6 and 3 and 5. Wachtel v. Allen Joel Communications. Submitted. Baton versus Pryor. Do you want any time for rebuttal, counsel? 3 minutes and 3 and 3. People versus Travis Rodriguez. Submitted. Rejulio, the SFP 7877th. 5 and 2 and 5. People versus Lance Lombard. Submitted. Red Hill Biopharma v. Kuko Co.
Good afternoon, Your Honor. Appellant with mediated Rejulio.
Very well. How much time would you like?
8 and 7. We request 8 and 7 minutes.
Thank you. And how much time would you like? Okay, I'll give you 6 and 2 and 5. Ray Stone Purchasing v. London Luxury is submitted. Brady versus NYCHA is submitted. First case up is CJS Industries v. Dolce. Please.
Good afternoon, Your Honors. May it please the Court, Brian Brick from Brick Law PLLC for the appellant CJS. We are seeking the reinstatement of the first, second, and third causes of action, which we've dubbed the fraud claims, just for ease of reference. The facts in this case are...
Counsel, was there an underlying tort that could give rise to these claims?
Well, there was.
I mean, there's a problem, isn't there, or at least raised by your opponent, with respect to the elements of fraud?
Well, with respect to the scheme to defraud, it doesn't actually require an independent underlying tort. What that goes to is the civil conspiracy aspect, which is actually a separate pleading that connects all of the defendants together for that tort. But for the baseline tort, which is the scheme to defraud, not only the prior panel that Honorable Mendez was sat on in 2023 that called the defendant's behavior reasonably suspect and questionable.
But it never said fraud. What's the allegation of the fraudulent conduct here?
So the fraudulent conduct is the incorporation of an identically named company literally right after losing the arbitration.
But that was well known, right? That was in papers that the other party responded to your filings. They indicated that that new entity had been formed.
That was not known until it was mentioned during the course of the confirmation proceeding.
But you knew who you were in arbitration with, the name of the entity that the arbitration matter was with regard to, right?
Well, yes, that was RS Custom Woodworking. It was the same entity as the name that was in first the master subcontractor agreement that was signed in 2018. The name Dolce, which I believe Your Honor is referencing, is nowhere to be found in any of those documents. It's not in any of the lien waivers or the lien releases that were signed for the periodic payments that were made to RS Custom Woodworking.
The fraudulent conduct that you're alleging, is that the name of Dolce, or is that the incorporation of the other name, the RS Incorporated name?
That is correct. It's the second. It's the incorporation of RS Custom Woodworking, Inc. So for 30 years,
So that was not a secret that this incorporated entity had been incorporated, right? When you did a corporation search, you found that company.
that's right, we found one entity. When we went, and my firm wasn't the one that conducted the arbitration, we were given the arbitration award, we were given the MSA to prove that there was an arbitration agreement. And when we conducted our search to make sure we were suing the right entity to name for confirming the award, we saw one entity, which was RS Custom Woodworking, Inc.
Why not name the entity that you were also engaged in the arbitration
We did.
matter with?
We did. So in the parentheses, on the caption, it says AKA RS Custom Woodworking, because the understanding was that they were one and the same entity. The name Dolce was not something that was known until after the Article 75 petition had already been filed, and then that was something that Judge Engeron actually discredited. He said, I don't believe what you are saying when you are telling me that it's a different entity. I think
Counsel?
that what,
Aren't there a number of claims that still remain, including to pierce the corporate veil?
there are, but not against the attorneys. And that's actually what I want to focus on, is that this isn't a situation where the attorney was some unwitting patsy. The attorney was directly involved, not only in the actual arbitration, because the attorney, Mr. Tremelli, handled the arbitration, but then is the one that filed the incorporation papers, literally weeks after losing when they hadn't done so for 30 years. And they've had, how many, 20 opportunities to explain why they did that, and yet there is no explanation other than that they did it to evade paying the arbitration award. And that's why, and the deceptive act doesn't necessarily have to be a secret. It is the fact that it has caused deception to the detriment of the plaintiff. And that is why, just to draw an
Well, there
analogy.
has to be an element of justifiable reliance, right?
Well, there is, and that is the fact that the entity was given the exact same name. And I want to suggest if,
But the date of incorporation of that entity is after the arbitration.
it was weeks after.
So
Weeks
how
after,
can,
so wouldn't that somehow put you on notice that it's not the same entity?
It didn't, because the understanding at the time, and this is what Your Honors will see in the caption for the Article 75 petition, it actually is pled RS Custom Woodworking, Inc., parentheses, AKA RS Custom Woodworking, because the understanding was that they were one and the same entity.
But
that
how
just-
could you assume that it's one and the same entity when this particular entity, Inc., was incorporated after the arbitration?
Because our due diligence showed that not only was it the same entity, RS Custom Woodworking, that was in the MSA, that was in all of the construction documents, that was named as in the respondent's award, and also that the arbitrator who conducted the arbitration never once mentioned the name Dolce, not even in any of the awards that he issued. So the name Dolce wasn't something that surfaced for the perspective of the award until after it was used in defense of, well, you've got the wrong entity.
Thank you, counsel. You have time to rebuttal.
Thank you, Your Honors.
May I?
Please.
Good afternoon, Justices. My first time appearing and arguing before this court, it's quite impressive. I would say it's a pleasure to be here, except for the fact that a necessity to clear my name of claims of fraud. In all my life, I've never been accused of fraud. I am Mark Tremelli. I am one of the
so
respondents.
counsel, you incorporate a company in literally the same name after the arbitration proceedings have already been completed?
So, Your Honor, I am a construction lawyer. I represent many contractors. It is not uncommon for them to have many similarly named companies because it is commonplace in the industry. And there's
How long had the company been in existence before this new incorporation occurred?
Dolce Custom Woodworking, Inc., which was a registered DBA as RS Custom Woodworking, existed since 1991. And the contract was entered as RS Custom Woodworking, not with an indicia of Inc. or LLC. It was appropriately done under General Business Law, Section 130. Same thing with the releases under the contract. Same thing with the checks. Everything was transacted under RS Woodworking, Custom Woodworking. Okay, Your Honor? Now, if I may, I was engaged after the arbitration was already in process. And Dolce, for short, Dolce Custom Woodworking, Inc., felt that they were being underrepresented. So he brought me in as the hearings were about to start.
During the course of the action to confirm the arbitration award, was there a response indicating that the name was inaccurate on that action?
Sorry, can you repeat that?
During the course of the action to confirm the arbitration award, when papers were filed by your side, did you respond in indicating that a defense was that this name that the action was started under, commenced under, was inaccurate?
Yes, on numerous occasions. In fact, as I was going to state, and if you give me a moment, so when I came on board in this arbitration, the first thing I did was ask to refile the answer and counterclaims because I thought they were deficient. And in doing so, in the legal answer and counterclaim itself, I spelled out Dolce Custom Woodworking, Inc., doing business as RS Custom Woodworking. Then, when that final award was issued in October of 2020. In December of 2020, the petition was filed to confirm against the wrong entity. I didn't merely deny his petition. I actually went the extra step and said, you have the wrong entity. It was incumbent upon counsel to withdraw and correct his mistake. Instead of correcting his mistake, he doubled down on it and is now lost in a motion to dismiss and is now why we're here today. He's trying to reinstate these claims against me and my firm for alleging a fraud on the pretext that I started a new company after an arbitration. Dolce Custom Woodworking, Inc. still exists. There's no fraud that's been perpetrated. There's nothing nefarious about starting a company. I do it hundreds of times a year.
So I'm looking at the record at page 207, and I see at paragraph 4, this is your affirmation, and it says, respondent was not in existence at the time of the purported arbitration agreement and entered, and even still did not come into existence until October 5th. As such, respondent could not and did not agree to the arbitration agreement and was not a party. And then you continue in the next paragraph. As set forth more fully below, the arbitration pertains to claims arising under an agreement between petitioner and another entity, non-party to this proceeding, Dolce Custom Woodworking, DBA RS Custom Woodworking.
That's correct, Your Honor.
Anything further? Thank you, counsel.
So, counsel, how do you reply to that affirmation from Mrs. Charmelli, wherein he's giving you the information that you're suing the wrong entity and that the correct entity is RS Dolce Custom Woodworking, Inc., DBA RS Custom Woodworking?
So there's two responses. The first is that, and what we argued to Judge Engeron was that what they really did was take a DBA and incorporate it, okay? That what they were really doing was, and this is what the facts picked up, they were doing this to evade the paying of the arbitration award.
But Dolce Custom Woodworking had been incorporated, I believe, in 1990.
They were, and not once did the name Dolce become mentioned.
Counsel, where's the fraud if you are advised in the inception of this action that you're suing the wrong company?
We weren't advised until after we had already moved to confirm the award. That's the point, is that I think there's a misconception about when we were notified that Dolce existed. And we weren't notified until there was a response to the Article 75 petition that had already been filed seeking confirmation against an entity that was called, in the caption, RS Custom Woodworking, Inc., AKA RS Custom Woodworking.
Was there any prohibition on amending the petition? Could you have amended the petition to add the party that was actually subject to the contract?
Well, I think in retrospect, amending it would have been futile because we're talking about, as this court then held, the entity that didn't exist at the time couldn't have the award confirmed against it. And we recognize that we went down the wrong path, and we did so because of what we were initially fed by the other side. This
You
was
weren't
intentional.
fed that. You went and looked that information up.
We did. This was an intentional act, and that's what the prior panel and Justice Kern and Justice
No,
Friedman
what the prior panel addressed was the potential for piercing of the corporate veil.
or similar
not-
remedies. And then when we filed the action afterwards, we had and it's in the record at the lower court, in the transcript, page 292 to 293. And this is what Justice Kotler said. This kind of sounds like you are trying to evade paying CJS. And I think that's what the appellate division was really getting at. And so when I read that little caveat, I
But
was
what
like,
did the appellate division actually say during the course of the arguments? They referenced the issue of piercing the corporate veil, not anything regarding fraud.
well, what Justice Kern said was that there was very questionable and very suspect behavior. Those were direct
Questionable
quotes.
and suspect doesn't equal fraud, right? There are other elements to fraud that have to be established first.
Well, what a fraud is it is an intentionally deceptive act that the other side reasonably relies on to their detriment. And that's precisely what was alleged here.
Counsel, when the red light is on, it's not time for black letter law. Thank you both very much.
Thank you, Your Honor.
We have your briefs. Next case up is People versus Claudio Rivera.
Good afternoon, Your Honors. Harold Ferguson for Appellant Claudio Rivera. It's the difference between specific articulable facts and speculation and generalities. What you have in this search warrant is the investigator making speculative conclusions, and
Is it conclusions, or is he reporting the facts as he sees them?
I don't believe he's talking about facts. He's talking about things like the reason they pick corner apartments is because they're trying to disguise the acrid smell of heroin.
Well,
But there is nothing in the record of this search warrant that indicates that there is any smell emanating from this apartment. He's taking, these are the basic factors that constitutes a heroin mill, and trying to gloss it on this without supporting it with facts.
And then he goes into what he actually sees happening on the ground. So the corner apartment, the person that is renting the apartment with, let's say, a fake identification, or Mr.
Cordoreal.
Although he's not the one on the lease, being the one taking the key, the pen register, the eavesdropping, the videos of him taking out garbage and other people taking out
The black
garbage.
plastic bags on the
black-
windows.
There's black plastic bags, but this is just as easily plausible that what's going on here is renovation of an apartment.
In the middle of the night? In the middle of the night, there's garbage being taken out as part of renovations?
Absolutely, Your Honor. And what you would look at is if they wanted to know what was going on, they could have followed the individual and found out what was in the garbage, but they chose not to. These are things that the police could have done, and they chose not to.
Now, this was a long-term investigation, wasn't it?
It was a long-term investigation.
Over a year.
Over a year, but it related to Mr. Cordoreal, which they could have arrested at any time. He had disappeared from the previous warrant execution. And
Counsel, what they could have done is not necessarily a factor in determining whether there's probable cause. Don't we have case law from this department that indicates that even cryptic or ambiguous conversations, when digested by an experienced officer, can support a finding of probable cause?
yes, Your Honor, but what you have here is the inherent problem of severely redacted search warrants. Here, none of this was before the trial court because trial counsel only had a severely redacted search warrant. If trial counsel had the ability to have the warrant, which I had and got as part of the appellate record, thanks to the Manhattan District Attorney's Office, many of these issues could have been raised at the motion to controvert the search warrant, but they weren't. So what you have is things like Ms. Rodriguez, it was a false number. We don't know that. They said Ms. Rodriguez never came back to the apartment, but they talked about that there was a time that a woman did enter the apartment. There were
Are
so
those
many
things the basis upon which making a determination of whether there's probable cause for a search warrant relied upon? Is that what we look to find out whether in fact there's probable cause for the search warrant?
I think you need to have specific articulable facts that indicates that it was more probable than not that this was a heroin mill. And I don't believe that's what's contained in this warrant. This is a bare bones warrant where the investigator is jumping to conclusions without justifying it with specific facts. And what we're asking this court to do is to look at the entirety of this. And this court is the first that's going to be able to fully look at this because counsels didn't have the opportunity. Both Mr. Corterials, who were before this court last year when their appeals were heard, did not have access to this warrant. So what we're asking this court to do is take a full look at this warrant to determine whether or not this investigator jumped the gun and made this application without having the requisite facts. Thank you, Your Honors.
Thank you, counsel. Please.
Good afternoon, Your Honors, and may it please the court, Caroline Williamson for the people. The trial court reasonably concluded that there was probable cause to believe evidence of a large-scale heroin trafficking operation would be present at the target premises. The affidavit supporting the search warrant in this case contained a highly detailed account of a lengthy investigation by an experienced investigator, and the fact that investigators knew that Juan Ramon was involved in a heroin trafficking operation because he had escaped them earlier actually weighs in favor of the search warrant because they lay out in meticulous detail in the affidavit how he was coming and going from this location and all of the other factors that you already mentioned, the covered windows, the phone calls that were being tracked, and the geographic location. All of these factors together made it very clear that he, a known heroin trafficker, was working out of this location.
Didn't the phone calls also have references to customers and deliveries?
Yes, Your Honor. He asked at one point, and he's caught on camera at the premises at the same time on the phone, this phone call saying, "Where are the customers?" And he's seen leaving the premises with a backpack and walking back into the premises without a backpack. So all of these factors are laid out very carefully. And while counsel points out that there are maybe possible conceivable ways that this could be an innocent explanation, it could be work was being done on the apartment. That's simply not the standard. There are cases that say, human imagination might conjure up possible innocent behavior to explain an investigator's observations, and that is not the test of probable cause. That's People v. Mercado, and we certainly don't believe that it is just as easily true that this was renovations being done.
The search warrant has to have enough specific information in it, though, right?
And we believe that the search warrant did have specific information. The investigator not only laid out the geographic information of the cell phone that they were tracking because it was known to be used in the heroin operation. They laid out the fact that those locations tracked exactly Juan Ramon, and they had intercepted phone calls that talked about customers. They also had him coming and going from the location. These were observable events, and those are things that are laid out within.
Coming and going from a location is not criminal, right?
No, it's not criminal. It just, coupled with everything else that was witnessed, it made it reasonable to believe that there was criminal activity happening here. If there are no further questions.
Thank you, counsel.
Your Honor, even drug dealers have to live somewhere. Just because Mr. Corterial is known as a drug dealer doesn't indicate that every place that he goes to constitutes a heroin mill. And if you take this, my daughter just had her apartment renovated, and it was done by her boyfriend and his friends. And they used the same type of activity that was here,
And they
covering
also
up
blocked the window?
Yes, covering up the windows so
They
that
took out the garbage and they went into a taxi and they transported it somewhere else?
yes, because you couldn't.
Was
you
anyone-
couldn't put that
anyone
in
a
under
part
New
of that?
York. It's under New York City sanitation law. You can't put construction debris into the regular trash.
Was anyone that was a part of that group in a previous, left from a previous location where there was a heroin mill?
No, Your Honor, but also, Your Honor, here, this is a very short-term thing where we're talking about DeKalb Avenue, that this was a relatively short period of time that this was under investigation. There were other locations that I talked about in Grand Avenue and other places in the warrant. So suddenly that is within a couple of days.
Well, it's a short period of time, but the same person involved, the same person who was at one heroin mill is now at another heroin mill and also conducting very similar type activities that denote that it's a heroin mill.
It denotes that he may be involved in narcotics, but the location itself, I don't believe, shows that it's a heroin mill. That it establishes that Mr. Cordereal is selling narcotics out on the street does not indicate that these premises constitute a heroin mill. And remember, Your Honor, the elevator doors open to the doors of this apartment. They could have seen, and it is on constant video surveillance. So there were times that that door was opened that was on the video surveillance that they could have looked at to see what was inside
I know
that
that's in
apartment.
your brief, but it seems like another reasonable inference would be that people who were running a heroin mill would not allow visible evidence of that to be evident when the door was open.
But the door opened, also they said that people left at various different times. So one doesn't know when the elevator doors are going to open and when someone's leaving the apartment. So there had to have been some point or time when the elevator doors opened and video surveillance was on that you could see inside that apartment to see what was going on inside. It wasn't a huge apartment. They could have seen inside. And if they had seen inside and saw that there was heroin, no problem. It would be a successful search warrant.
Do you have enough further questions?
I have one question.
Please.
Since you're claiming that it could have been construction work being done there, and you mentioned just the black bags, plastic bags, were there any other indicia of construction? Were there permits? Were there tools?
What was carried in was backpacks. What was carried in was black garbage bags. What was taken out was black garbage bags. No matter what you think the investigator is, he isn't Superman. He doesn't have X-ray vision. He can't see inside those bags or in those backpacks to tell what was in them.
But he's an experienced investigator who has been doing this for many, many years, and he knows a heroin mill when he sees one.
Then it sounds like Potter Stewart, that I know it when I see it.
Possibly, but he provides a lot of facts to substantiate his conclusion that it's a heroin mill.
I respectfully disagree, Your Honor. Thank you very much for your time.
Thank you, counsel. Thank you both. .302 West 87th, the SHS Upper City.
Morning, Your Honors.
Morning, counsel.
Isaac Menasheroff.
Afternoon, but yeah.
Oh, afternoon. Isaac Menasheroff, Stinful Menasheroff, and Buncher for Appellant SHS Upper City. My first time here today. It's a great honor. A little nervous, that's why I said the morning. So the way I want to start the argument today is I want to talk about which causes of action were brought by the respondent and which weren't. The causes of action that were brought by respondent are ejectment, trespass, use in occupancy, and negligence for damaging a wall. What the respondents didn't bring are breach of contract, breach of a license and access agreement, cause of action to enforce a license and access agreement, any cause of action with respect to RPAPL 881, or any cause of action with respect to RPAPL 81 in general, right? So against this backdrop, the argument here is that the lower court should have dismissed respondents' request for attorney's fees, which, by the way, were brought for the first time. The demand was set forth for the first time in their supplemental bill of particulars. It's nowhere in the complaint. Okay, so on that alone, it's an improper expansion of the case. Now,
Excuse me, are we talking about the license that had expired?
Right. So
So-
when I said that the license, the license that expired is not part of this case. The license that expired was part of a tangentially related license, RPAPL 881 proceeding that my clients brought to obtain access to the respondent's building in order to install temporary protections. Now, that license agreement that expired has nothing to do with this case.
Okay.
It's really a procedural issue. And it doesn't grant attorney's fees in this case. Again, this case is a common law trespass, negligence, ejecting the cause of action. Now,
But
respondents...
this case is in relation to not vacating the premises based upon that expired license, right?
I'm sorry, I didn't understand. There's cases for what?
This case is in connection to that previous case regarding the license because there hasn't, your client hasn't vacated the premises based on that license that it was given that expired.
Well, yeah, I think procedurally, I think it's related. However, the respondents in this case do not bring a cause of action for breach of that license and access agreement, to enforce the license and
Because it's expired, so now they're seeking to have you ejected from the premises based on that expired license.
Well, they could have brought a cause of action to enforce the license and access, saying, hey, we're enforcing the license and access agreement, it expired, you have to leave. But that's not what they did.
That's not what the,
Does RPAPL 881 require that all the damages be sought in one action?
I doubt that, well, I don't know. The short answer is I don't know. However, I'll say this. If they're not asking for RPAPL damages in disciplinary action, I don't think they should be granted here where there's no such cause of action pled. They're pointing at a separate, distinct, disposed RPAPL proceeding that simply doesn't exist here. It just doesn't. Which is why the attorney's fee issue is, there's no statute in this case calling for them to get attorney's fees. There's no contract, there's no license and access agreement. And American rule, as you all know, everybody bears their own litigation costs, okay? And the kind of, in sort of the same backdrop, the use and occupancy damages, we believe that the court improperly granted those damages, first because it was a liability motion. The respondents weren't seeking damages on a motion, but the court looked at this expired license and access agreement that's not part of this case and said, well, we'll just use those numbers and grant them the damages in a case where damages are not the only fact left for trial. There's still this negligence cause of action that liability still needs to be tried. So the lower court could not have ordered damages. They could have ordered an immediate trial on damages, but they didn't do that because damages are not the only issue on trial. There's also this negligence cause of action that has to be dealt with, okay?
Wasn't that on the UNO? As per the license was $1,500 for the UNO, and that just continued for the time that you stayed on the premises, correct?
Yeah, well, that $1,500, which we paid for the duration of the license and access agreement, it expired. Then before this case action ever started, we came up to the respondent at SHS and said, hey, we would like to continue the license. We would continue to pay you the $1,500 and all the other things that are part of this license agreement. They said no. We brought another RPAPL proceeding trying to remove our stuff from the respondent's premises. They said no. And they started this case in order to get $5 million worth of damages from my client.
Thank you, counsel. You have time in rebuttal.
Thank you, Judge.
May it please the court, my name is Theodore Hecht, and I represent the respondent. Much of his argument about these causes of action, I don't think are found in his brief. I think it's just something that he came up with right now. But the bottom line here is that there was an RPAPL action proceeding brought in 2017. The Justice Edmead, in the prior proceeding, gave a license to the defendant for 12 months, which expired on March 24th, 2018. And the defendant simply didn't vacate, and didn't vacate until, never vacated. It's still there, you know, it was still there when the judge issued the summary judgment motion. As far as I'm not sure what he's really arguing here. We made out there's a trespass because the license expired and he remained. That's a trespass. Ejectment is an appropriate remedy when someone is sitting on your property and you want them off. In their brief, they argued that it doesn't apply because they weren't in possession. But if you look at the photographs, what they installed on my client's property is not some de minimis, you know, widgets. It's this massive structures. There's this roof protection. There's this sidewalk shed that extends the full length of the yard. They installed pipe scaffolding, which was not authorized by the 881 order, which was blocking tenants' windows. I mean, they were hurting my client's tenants.
No, that's fairly established in the record. Do you want to talk about attorney's fees for a moment?
Yes.
Like, did you have to move to restore the 881 to get attorney's fees, or can you get them here in this plenary action?
We could get them here in the plenary action. There's, you know, when the judge's estimate, when we went back to her, when my client went back to her, because they were still on the property and expired, the justice took the position that the case was closed and we needed to bring a new action. We brought the new action because we were directed by the court to do that. And as far as the attorney fees, it's not the American rule. It's not an incident of litigation. Under the 881, the license order, they have to indemnify us from all
It's
lawsuits.
definitely provided in 881. It's just, this is not an 881 action. This one we're in front of right now. You know, it came from your initial 881 action, but does the attorney's fee provision somehow survive into this plenary action?
It does. And again, we only started this action because we were directed by the 881 court to do so. And it's not, as I mentioned before, it's not an incident of litigation. It's part of the damages in an 881 case. And we cited, in our brief, we cited several cases which stand for that proposition, that attorney fees is just one of the costs, one of the damages. Remember, in the 881 proceeding, it was not for our benefit. My client received no benefit from this. It was only for their benefit. And what they did, which was outrageous, is that when it expired, they refused to leave. And the appellant didn't mention it now, but throughout his brief, they claimed this is an extortion plot. An extortion plot. That's really, it's just a completely outrageous. And I don't know, are they criticizing the judge as now being an accessory to this extortion part? I mean, it's just, they didn't oppose the motion with any evidentiary material. It was based exclusively on counsel's affirmation. They submitted these stale pleadings and affirmation from years ago, which don't even address the issues in the case. Unless there are any other questions, I'll rest.
Thank you, counsel.
We did vacate. They told us to leave and we left. We had initial access. The access terminated. We attempted to extend it. They said no. We left. Okay? There cannot be. You can't be ejected from what you're not in possession of.
You left a lot of stuff on their property. That's the issue.
Well, we asked them to remove it, which we started a whole separate 881 proceeding, essentially begging them to take it away. And they said no. So how can we be ejected from a premises that we have no right to even enter? That cause of action simply on the law does not make sense. Same thing with the trespass. How could we be trespassing somewhere we can't even enter? If we could, we'd remove the stuff ourselves, but we couldn't.
Because you were given a license for 1 year to get it done, and you didn't get it done. Your stuff is still on their property.
If you take a look at the transcript from the 881 proceeding with Judge Ed Mead, she understood that these sort of projects don't take a year. she knew there was going to be negotiation after the initial expiration.
And what
date.
she indicated is that while the license was still valid, if you needed more time for you to come back to the court during the valid period of the license.
And we tried, and we tried. When the initial license, what she said was, work it out amongst yourselves. If you can't, come back.
Right, but the time that you came back, the license had already expired.
Well, Your Honor, I don't think she said that you have to work it out before the expiration date of the initial.
But you don't have a license. You don't have a basis to be on the property if the license has expired.
Which is why we left and tried to renegotiate it.
But you left your things there.
We weren't allowed to take them away, Judge. That's the whole point here, is that how can there be a trespass or an ejectment if we can't leave? If they're not letting us take away the property, how can there be an ejectment? And that's really, and again, counsel keeps arguing 881. This case has nothing to do with 881. It's a common law negligence, ejectment, and trespass case.
But that's because the court directed the petitioner to file a plenary action.
That's not what the court did. The court they brought these claims to Judge Edmead. Judge Edmead told them, this has nothing to do with my license order. If you want to go chase damages with respect to your damage wall, go start a new action.
That was because the license expired?
No, that she didn't want to reopen the case.
Because the license expired.
Well, again, they were trying to argue that they'd have these damages, that they would extend the license if we do X, Y, and Z. We said okay, but they wanted, I think, $250,000 worth of attorney's fees, and she said, with respect to the damaged wall, go start a new action. But again, they continued to decline getting the additional license, and they started this case that has nothing to do with 881.
Thank you, counsel. Thank you both.
Thank you, Judge.
Gates, excuse me, Gates v. NYU.
Good afternoon. May it please the court, Gail Kellner for plaintiff appellant in this case. Although we have been compelled to appeal from both an original order and the denial of a motion to renew, I think the most important factor in this case, which is brought under Labor Law 240 and 241 sub 6, is that this was not an unwitnessed accident, which sets it apart from many of the cases upon which the defendants rely. This is an accident that happened in a very busy machine room under construction.
There's some variation in the descriptions of the accident in the C3 form and in the medical records. Let's start with the medical records.
Okay.
Are they properly authenticated?
I don't believe they are, Your Honor, although it mentions that it's from patient. It does not state who the historian was who wrote the records.
And is it germane to treatment?
I'm sorry?
Yeah, the etiology of the accident, is it germane to treatment?
I don't believe that the details of this accident as to the manner in which he came off the ladder were germane to treatment in the first place. And in the second place, I don't think that the person who took down the history was documented. But I also think what's important here is that I don't think that there is a material difference between the manner in which the history was related in the hospital record, which also states at one point that he fell. Plaintiff fell. Patient.
Right, but what it states is that he fell after he was already off of the ladder, so that the fall was attributed to debris on the floor and not a fall off of the ladder.
Okay. I think that the answer to that is that this is a case where there are two proximate causes of this accident. The first part of it is that there was an uncontrolled descent from a ladder which wobbled, causing him to come off the ladder in an uncontrolled manner and then land on a piece of debris, which further exacerbated the situation by causing him to roll forward and to fall. I don't think that you can separate the two elements. I think there are two proximate causes here. And I think you can't state that he fell on debris without noting that he came off the ladder in an uncontrolled manner when the ladder wobbled.
And coming off an uncontrolled wobbly ladder, that was the first in time incident that happened. So in other words, there was a gravity-related incident,
Yes,
and then perhaps that was exacerbated or not by the debris on the floor.
correct.
The reports after the accident, which he signed, don't reference a wobbly ladder or an uneven floor. Is that not correct?
I think that there is no reference in these reports, which he did not prepare. First of all, it was prepared by Mr. Serino, who.
But he signed
supervisor,
both
but,
reports, right?
I think this court has previously found that as long as the accounting of how the accident happened is consistent, it does not matter if all of the details were stated in each subsequent rendition of how it happened. Very recently, in fact, in a case of mine when I was before this court in May, in a case called Duran versus Erie, and it's 238 AD 3rd 665, this court found that even if a description of the accident did not always contain all of the details of what occurred, as long as these accounts were not inconsistent, it did not rule out the
Right, so the
additional-
question here is, do we have details that were left out or different versions, inconsistent versions of what caused the accident?
I think we have details that are left out, Your Honor, for the single most important factor in this case. This is not an unwitnessed accident. Plaintiff and his coworker were both in the room when it happened. His coworker provided an affidavit and was deposed and thoroughly questioned by defense counsel and stated that the ladder was placed in an uneven situation because of a trough around the side of the machine room, as a result of which the ladder was not completely stable. It rested on 3 legs instead of 4, and that as Mr. Gates was coming down the ladder wobbled because of its positioning, which was the only way it could be positioned for the work being accomplished, caused the ladder to wobble, caused him to miss a step, come off the ladder in an uncontrolled manner, and there is no dispute that after he came off the ladder in an uncontrolled manner, that his foot came into contact with it.
Just so that I understand your argument, so that I'm sure that I understand your argument correctly, what you're saying is that the reports, because we have 2 witnesses to the accident, those 2 witnesses essentially can trump the reports that were filed after the accident reports.
They did not contribute to the reports. Neither his coworker, Mr. De La Cruz, nor Mr. Gates wrote those reports. They were provided by Mr. Serino.
Mr. Gates signed both reports, though, right? And after he read them.
We don't know for a fact whether he read them. He stated he was in extreme pain when they were prepared, and he signed them. He admits that with his non-writing hand, his non-dominant hand. But they are not inconsistent with the eyewitness testimony, Your Honor. He did not write out either of these. He did not make recorded statements. These were prepared by a person who admitted he was never in the machine room, did not go into the machine room, and was not a witness to the accident. He wrote the reports, not Mr. Gates and not Mr. De La Cruz. We have eyewitnesses who state
Thank you,
the
counsel.
full
You have time in rebuttal. Thank you very much.
Thank you, Your Honor.
Please.
Good afternoon, Your Honors. Nate Drexler, Galavitucci-Clar for the respondents. I'd first like to address the portion of the plaintiff's testimony on 778 of the record, where he did admit that he signed these accident reports with his right hand, and he signed them. Thereby, he's bound by them. There's ample case law from this court that says the same. The fact that a plaintiff may have made a mistake or a mistaken assumption that a certain paperwork was merely a sign-up sheet is the case law in Blog v. Battery Park.
So say he did sign them. What's the nub? What's the crucial contradiction?
He was asked, Your Honors, to tell his story on 3 different occasions through these reports. If, in fact, Labor Law 240 is involved here, and if, in fact, this ladder was wobbly, causing him to fall, if the floor was uneven, if it was a defective ladder, he surely would have said something in the report. These are not just vague reports. These have some bit of specificity to them, including the fact that after he fell and landed on debris, he used his hands This is on 954 of the record. He used his hands to stop his fall and tweak his left elbow. He decided not to go to the emergency room. He mentions that again in 955 on the C3.
Counsel, how do you square that with, for example, the Rodas case that that the opposing counsel cited too, that said, wherein opposing counsel said that that case was squarely on par with the facts of this case?
This is not a matter of missing details. This is the exact facts that would lead to a specific cause of action causing him to fall. Because, Your Honors, there would have been no issue if he stepped off the ladder and stepped onto debris. That's very, very different than...
So, for example, cases where the individual says that they may have lost their balance and later says that the ladder was wobbly, that's an omission, that's not an inconsistency.
That's
right?
correct, Your Honor. And these are admissions, and if not admissions, they're statements against interest, including the one at the emergency room, which is at 997. He says it the exact same way. He stepped
How is that
off a
authenticated, though? Same question that we asked opposing counsel. How are those emergency room documents authenticated?
They're, first of all, in our opinion, admissible because they're statements against interest and they're admissions. Secondly, they're not the only pieces of evidence that are being provided. They're simply bolster what's already there in those accident reports that were taken contemporaneously with the accident and signed, as this court noted, by Justin Gates. And I would like to also point out, with respect to those, these were not long, laborious descriptions. These are 3 sentences where he signed right underneath it. So the idea that he may or may not have understood or may or may not know what it said and just signed blindly, first of all, First Department case law doesn't care about that. But second of all, it simply doesn't pass the common sense test.
So, counsel, going to the report prepared by Mr. Serino, I believe, that the plaintiff signed, on 954, he does mention tripping on material that was on the floor.
That's correct, Your Honor.
So isn't that, if that is correct, that there's material on the floor, and that he trips on that material, is that a violation of 241 sub 6?
We respect...
Like Ms. Kellner said,
we respectfully...
this is 2 proximate causes of action.
Understood. We respectfully submit no. And this is because the issue of fact here is now you have a major credibility issue for this plaintiff. He's telling 2 stories. You know, counsel here says there may have been 2 proximate causes. Okay, well, the story that there's 2 proximate causes is very different than the story of this is a labor law 240 case where a ladder wobbled and I fell off. So either way you look at it, it's conflicting testimony. It's a conflicting.
The problem that we have is that he was not the one that gave the information for to prepare these reports. According to Mr. Serino, he doesn't even remember who gave him the information. And Mr. Killmeyer, where it's got a section that says reported by, it's left blank. So who provided that information, we don't know.
The problem, Your Honor, respectfully, that Mr. Gates has to fight against is Blog v. Battery or Shaw v. Monpot Construction Company. The fact that he may have mistaken or had mistaken assumptions about a contract does not relieve him from being bound by it. He signed the report. If he was mistaken about it, if the information came from somebody else, he shouldn't have signed it. And he did, and he's bound by that.
Thank you, counsel.
Thank you.
First of all, just to separate out the 241.6 and the 240, there has never been any dispute, whether in the accident reports or in the accounts of Mr. De La Cruz or Mr. Gates, that there was a piece of electrical conduit debris on the floor and that he did have his foot roll on it and fell forward. So I think that the 241.6 aspect has always been distinguished from the 240 part of this. But again, our contention has been there are 2 proximate causes to this accident. He had an uncontrolled descent, landed on debris, and rolled and fell.
Are you saying, Ms. Kellner, that so landing on debris, game over, it's 241 sub 6 liability?
I'm sorry?
I'm sorry.
I just didn't hear you.
Are you saying that the debris is a constant and therefore there's 241 sub 6 liability no matter what?
I would say so, Your Honor. I think that's always been fairly consistent in this case. But all of the statements made by my adversary are completely saying, let's disregard the fact that this was a witnessed accident. Mr. De La Cruz was deposed. Mr. De La Cruz gave an affidavit. Mr. De La Cruz testified to the position of the ladder, to the wobbliness of the ladder, and he saw the accident.
Mr. De La Cruz was,
Eyewitness testimony for the sake of an accident report.
counsel, quick question. Mr. De La Cruz was represented by the plaintiff's lawyer as well, right?
We did represent him only at the deposition, Your Honor. There was no effort made to keep him from talking to adversarial counsel. He was allowed to talk to whomever he pleased, and at that deposition, the only thing that was done was to make sure that questions that were asked to him were properly placed. And there is nothing in the case law or statutory law that prevents him from being represented by plaintiff's counsel as long as we in no way impeded defense counsel's access to him, which we did not. So I think that that representation, and if you read the transcript, you would see that there was no obstruction and any effort to keep him from answering all questions. And again, both he and Mr. Gates' deposition testimony is very consistent as to manner in which this accident happened and distinguishes it from all the unwitnessed accident cases. Thank you.
Thank you very much. Thank you, Barry. Counsel. Severini versus New York City Department of Environmental Protection.
Good afternoon, Your Honors. May it please the Court. Gil Perez from the law firm of Gil Perez for Hunter Severini, the appellant in this matter. Mr. Severini is a citizen complainant. This is a new procedure the City of New York instituted whereby citizens bring about certain types of violations. This particular violation was an air pollution violation.
Yeah, we know the facts, counsel. Why do you say that hearing officer Pitter was biased? I see nothing in the record that supports that. He ruled against him, but why do you accuse him of bias?
The decision that the hearing officer recited clearly stated that she found in every single way for Mr. Severini, she saw each one of his arguments, she gave credibility to all of them, and then in the end simply said, however, he's guilty. And I thought that...
Isn't this the claim where your client submitted 4 times?
Yes.
Okay, and weren't some of that video or be altered?
Video was never altered. Same video. In fact, the video was submitted by the city as a record, and it was the video that they received. There was no alteration to the video.
Okay, so there were decisions for prior times?
There was only one decision. All subsequent decisions were made by the issuing officer who never reviewed any of the evidence presented by the citizen complainant. The only person who reviewed the information presented by the citizen complainant, Mr. Severini, was the initial officer who rejected it. Mr. Severini has submitted a lot of these complaints, and he regularly resubmits them where he's rejected because he has reason to believe that he has the video and it shows for 3 minutes or 4 minutes, however long it's supposed to be, that these vehicles have idled incorrectly.
But each of these complaints somehow had 1 or 2 details that was changed. And that's where the reviewing officer found that Mr. Severini was being misleading because he did not submit exactly the same complaint. In one, there was a letter that was changed on the plate. In another one, the address was listed differently. And so these were the things that actually caused the reviewing officer to say, you're changing these little details here and there and submitting the same video to me, and I've already told you that you have not proven your case, and yet you keep coming back. You are being misleading.
The changes that Mr. Severini initiated were to the address, which were all linked to the GPS location.
Did he make a change to the license plate?
Mr. Severini said in testimony, and the hearing officer found credible, that it was a typo. And
This
Mr.
is,
Severini submits a lot of
substantial evidence is the standard here, correct?
substantial evidence. However,
it's a very lenient standard for the agency, correct? Yes, is the
Your
answer to
Honor.
that question.
Yes.
All right, counsel, why don't you finish up?
As lenient as the standard is, where there's clear evidence to the contrary and the hearing officer doesn't consider it, and where the hearing officer halfway through the hearing says, well, that's not relevant. The person who issued the initial rejection isn't a necessary component. We feel that the oath tribunal really did not afford Mr. Severini a fair hearing at the initial trial. And thank you.
Thank you very much.
Good afternoon, and may it please the court. Chloe Moon on behalf of DEP and Oath. Substantial evidence supports the board's determination here that Severini knowingly made misleading statements. He filed the same evidence, videos and photos, of allegedly idling vehicles 4 times, but in each he changed the address and in one time changed the license plate number. He also labeled those later complaints as additional, quote, offenses for those license plates, for that license plate, revealing his awareness that he could not merely resubmit the same already rejected complaint over and over again. I'd quickly point this court to the evidence, and as this colloquy has already made clear, substantial evidence is a very lenient standard for which, even if there's contrary views, as long as there's support for this evidence in the record, this court should affirm. That evidence is the second offense, the third offense, that's at R86, R96, 105, that's written in. So Severini had to write in that this was the second offense for the same license plate. And I'd note that if there are multiple offenses, complainants get more money. So that's an important part of this handily added into that description. I'd also
So complainants are paid for making these reports?
Yes, Your Honor. I'd also point to the inspector's testimony where the inspector for the second, third, and fourth complaints, the complaints that are at issues that had the misleading statements in them, say that the same time and address will not be accepted by the DEP system. So the only way to get it through to a vetter to actually look at the evidence is to change the address. And that's what Severini was doing here. And I'd also point this court to the evidence that said that the evidence was not correct, quote, not correct at R151. So all of that went into the board's determination that Severini knowingly made a misleading statement here. I just quickly point also to the inspector specifically. It's the second, third, and fourth complaint. The inspector who rejected those is the one who came and testified. And obviously that's relevant here because the point of this petition was Severini's challenge to DEP's summons. It's not a challenge to his initial complaint. It's only to that DEP summons and the penalty that was imposed. So we ask this court to affirm.
Thank you, counsel.
Thank you so much.
No further comment.
Okay, thank you, counsel. Thank you both. Deutsche Bank versus March.
Good afternoon. May it please the court, my name is Patrick O'Keefe and I represent Appellate in this argument. The material facts were undisputed in this case. There was no, the burden to raise a tribal issue of fact was not met by the respondent. There was no,
But the note was attached to the complaint, correct?
a photocopy of a note that was
A
attached.
copy was, and it was endorsed in blank, correct? So
Yes,
why
Your
isn't that enough?
Because the complaint was not verified. So you have a case where there's been no appearance from the plaintiff. You have an unverified complaint with a photocopy of a note, which is submitted in opposition to summary judgment. There's no affidavit from a person of knowledge. The evidence in itself is in inadmissible form. There was no proffer or explanation of why the evidence was submitted in inadmissible form. So what you have is a note from the BIS and the summary judgment motion. If this order stands from the lower court, then tomorrow I can pull a note from ACRIS, commence an action, and file for summary judgment. And technically, I can foreclose on the person's home. There is no plaintiff. We've never seen a plaintiff. There is no affidavit from anyone with personal knowledge.
What about the affidavit from Ms. Tharab, is her name?
There was an affidavit in regards to the second, the appellee's renewed motion for summary judgment. It was an affidavit of indebtedness, but it did not submit any information with regards to the crucial fact of when the plaintiff allegedly received the note or when the note was delivered. So all we have is a photocopy of a note. It's just a picture. We don't have an affidavit from no one.
Is there any case law that says a photocopy of a note is insufficient?
The case law says that the original note should be delivered. So, and a photocopy is sufficient for a motion to dismiss.
You rely on Ceccarelli, though, but did Ceccarelli make that distinction between verified and unverified complaints?
Yes, Your Honor. But in a summary judgment motion, there has to be an affidavit from a person of knowledge, or the evidence has to be in admissible form. You can't just submit a photocopy of a note. That would be sufficient for a motion to dismiss, but not for a summary judgment motion. If the court has no more
Any further questions? You have more time, counsel, if there are any points you wish to add.
In Appellee's brief, they fail to distinguish that distinction, which is that a photocopy is sufficient for a motion to dismiss, but not for a summary judgment. If the court looks at this, all we have, as I've stated before, is a complaint that's not signed by the plaintiff, is not verified by the attorney that filed the complaint, and there's a photocopy of a note attached to it. And that's all that there is in the entire case. There were also 4 prior rulings from Judge Suarez that denied the same summary judgment motion. I do not believe Judge Suarez was wrong or missed out something that this judge, the lower court, now ruled or found. Judge Suarez pointed out to them that it wasn't sufficient to establish standing. At summary judgment, you have to prove standing. At a motion to dismiss, you can just state standing, as that's just based on the pleadings. But here we have nothing. There's still no plaintiff, and there's still no submission of an original note, a certified copy, an explanation of why the original doesn't exist. There's no evidence supporting when they received the note, besides it being, as I said, the photocopy being attached to the complaint.
So basically, you're saying that because you don't have anybody providing an affidavit saying this note is a copy of the original note, then there's no standing. Summary judgment shouldn't be granted.
I'm saying that in opposition to summary judgment, you have to submit an affidavit from a person of knowledge or submit evidence in admissible form, and neither one was done here.
Okay.
As such, that was a reversible error by the lower court. Thank you.
Thank you, counsel. You have time to rebuttal.
Good afternoon, and may it please the court. I'm Robert Yusko, McCabe, Weisberg, and Conway for the respondent. Counsel would ask this court to ignore its own case precedent, specifically U.S. Bank Trust versus Stewart of just last year, and before that, Bank of New York versus Knowles of 2017. In U.S. Bank Trust versus Stewart, this court held, I quote, U.S. Bank Trust established standing at the commencement of the 2017 foreclosure action by attaching a copy of the note endorsed in blank to the complaint. Years before
Was
that,
the complaint verified in Stewart?
this court didn't specify whether it was or was not, but in Bank of New York versus Knowles, which I'd like to address, holds similarly to Stewart, but goes on to say, if the note is affixed to the summons of complaint, it is unnecessary to give factual details. Moreover, even though not required, plaintiff also provided affidavits. So the court's clear precedent, this court's clear precedent, is that annexing a copy of the note to the complaint at commencement establishes standing at that point, and no further affidavits are required.
What about your opponent's point that you can just pick up a note from Acris, attach it to it, slap it onto a complaint, and say, "Hey, game over. We prove our case." In other words, a little bit troubling here is the absence of competent evidence. Is there competent evidence when you just have a copy of a note attached to an unverified complaint?
Well, Your Honor, what I would say is an assignment was also recorded concerning the assignment into plaintiff. So as a matter of record, since before 2012, plaintiff has, as a matter of record to the world, been the entity withstanding to commence the foreclosure. And a certificate of merit was filed in this case
But you got the previous decisions by Justice Suarez, so how do you square this decision with those decisions? Because he denied your motions for summary judgment 3 times, I believe. What additional proof did you have on this motion, which was made by Mr. March, that was different, that was in front of Justice Suarez?
Well, Your Honor, I believe the reason why a different result occurred in this case is because it was taken in together with the determination by the court that standing was established at commencement via the summons and complaint. So when our motion for summary judgment at that point included the client affirmation together with the recorded assignment of mortgage taken in totality and pursuant to this court's precedent, again, from just last year and from 2017, plaintiff established its standing at commencement pursuant to the case law that controls.
That's the affidavit of Ms. Tharab that I alluded to earlier? That affirmation from the client, is that it?
I'm not sure I understand your question. That affirmation was filed in the motion papers.
Mm-hmm. And it addressed standing.
It did not address standing, but I would argue that as to counsel's point concerning a verified versus unverified complaint, cases, all the cases pending for quite some time now have a certificate of merit filed, whether they're either filed with commencement, if they commenced at a certain time, or if they were still pending, required a certificate of merit to be filed. In this case, a certificate of merit was filed in 2015 that I would argue is equivalent, if not better, than a verified complaint.
Thank you, counsel.
Thank you.
Again, with regards to the summary judgment motion, the attorney's affirmation has no probative value. It can be used as a vehicle to bring in evidence, but the evidence has to be in admissible form. A summary judgment is like a trial. You can't just come in and submit copies. It defies all the rules of evidence. You have to bring in accordance with the rules of evidence. Attaching a photocopy to an unverified complaint and using that as the sole basis for summary judgment is unheard of. I couldn't find any case law that supported that. Secondly, with regards to the affirmation of indebtedness, that was submitted in conjunction with Appellee's motion to renew summary judgment. Appellant's motion for summary judgment came first, and that was denied. But there was no opposition. Their opposition was a nullity. There was no affirmation from a person of knowledge and no admissible evidence. And the law mandates that summary judgment should have been granted to the appellant. If the court has no further questions, I'll rest.
Thank you, counsel. Thank you both.
Thank you, Your Honor.
Southern Israel versus Orgenesis.
Good afternoon, Your Honor, and may it please the court. My name is Martin Beanstock. I'm an attorney for appellants plaintiffs in this matter. My clients loaned $1.15 million to the respondents. The loan term ended. They haven't gotten their money back, and we're entitled to summary judgment ordering them to pay the amounts that were loaned. There are certain fundamental facts that are either undisputed or shouldn't be disputed. The parties entered a convertible loan agreement. I think that's agreed on. I think that was pleaded too. The agreement said we were supposed to lend them $5 million. We only lent them $1.15 million.
Right, which they say put them in a bad position in that they had committed certain expenses that they needed to cover with the 1.5, and that they also had to seek other loans at less favorable rates. So we're talking about duress at this point. Can a defense of duress come up after the signing of the foundational document?
No, Your Honor. Duress in entering the contract is only prior to the entry of the contract. That's black letter law, Your Honor. So, I mean, fundamentally, it's the $1.15 million. They have a counterclaim for breach of contract, which we think that will not be successful because we think they understood and agreed to the fact that we were only going to lend this money, we were going to get other sources to pay the rest of the contract, but that's not at issue here. That claim still remains. Under Capital One Taxi from this court, we're allowed to collect on, or at least get summary judgment on our claim, and they're entitled to pursue their counterclaim.
Don't we have
later.
case law that says that when they have a counterclaim that might exceed the amount of your claim, that we shouldn't grant summary judgment to you on your claim that has a lesser quantified amount?
I'm not familiar with that case law. It wasn't cited in the papers, but I will say, Your Honor, that on a loan, it's very clear, and the court, the CPLR even has special provisions for loans to be collected by petition in lieu of summary judgment, a complaint in lieu of summary judgment. This isn't exactly that, but it's the same idea that when you loan the money, they don't repay the money, you can get summary judgment to have the money repaid. And Your Honor touched on...
Unless there are counterclaims that can offset what is to be paid back, correct?
Well, not in this court. I think we're entitled to the summary judgment. The question is maybe whether we can collect on that judgment below. That might be for a later proceeding. But in terms of whether we're entitled to summary judgment on that claim, that's Capital One Taxi, and the court in that case did not say that if there's a counterclaim or there's some excess, that gets deferred. So we are entitled to summary judgment on the loan for the $1.15 million. The case isn't over necessarily. We think the counterclaims are very weak, and we think that's why they haven't pursued them. That's why, 3 years later, we haven't seen a claim. We think they were waived. And in fact, if that's necessary in order for this court to reach that decision, I think they are waived. They were never previously prosecuted. So we think that they were waived. But it isn't necessary in order for this court to approve of the summary judgment on this claim in order to award us summary judgment. The other defenses, I think are equally weak. As Your Honor pointed out, there's no duress. The breach is a counterclaim, but it isn't a defense to our claim, and we do think it was waived. They reference dealings between a portfolio company and their company, but those are documents and transactions that weren't related to the lenders, that were just from a different corporation.
Was the subject contract here ever fully consummated?
The subject contract, meaning the original convertible loan agreement, Your Honor?
Yes.
By consummated, the parties agreed to the contract?
Well, it was supposed to be fully funded by a certain amount of money, correct?
Yes, Your Honor.
Was it ever fully funded?
It was not, but it was partially funded. And so at worst, there was a partial breach.
Right, and
they had the
so-
right to reject the contract and return the money.
With regard to that partial breach, are there any potential damages that they may have incurred because of that partial breach?
So we don't think so, because we think they've waived the breach. They have never pursued it. We agreed with them. We argue.
But is there a basis to deny your summary judgment motion if, in fact, there is this potential that there are damages based on those counterclaims that could offset the amount of money that you say you loaned them?
I don't believe so, Your Honor. I believe we're entitled to summary judgment on the claims, just as they were in Capital One Taxi. When you loan the money, you're entitled to collect the money through summary judgment proceedings without regard to the counterclaims.
Thank you, counsel. You have time, rebuttal.
Good afternoon, honored justices. My name is Stephen Feinberg. I'm appearing on behalf of the respondent. First, I'd like to say that there seems to be a big skip here over basic contract law. There was a long negotiation between the parties for a $50 million loan, which never came to fruition. Part of that negotiation was the request that my clients take over a company that the appellant owns, and to make it profitable, because that would have been a big windfall for them. That was not agreed upon. Subsequently, there was a $5 million loan that was negotiated. That document was signed by the parties. That loan was never funded. 3 days after the signing of the document, $1.15 million was wired to my clients. with the proviso that, oh, we'll either fund the rest of the $5 million or we will come up with some other arrangement. And this is the basis of our case, was that there was a continuing negotiation. Now, Judge Frank below found duress. He found duress in the acceptance of the 1.15. If you read his entire decision says, especially on the money loaned cause of action, that he doubted that there even was the existence of a valid agreement between the parties because of this long drawn-out negotiation. You can't just ignore the conduct of the parties pre-contract and post-contract, because there was a valid negotiation going on by the very entities.
Does the CLA have a merger clause in it? I don't remember.
The CLA had a clause that the contract could not be amended unless it was in writing, and there was no merger clause. The contract was never amended in writing for the $5 million. The CLA was specifically negotiated with amounts that the loan could be converted into stock. So what do we do with that? If they gave an arbitrary amount of money, we have to then figure out later on what the conversion to the stock ratio was. The CLA was never a valid agreement. Basic contract law, one of your honors is a noted professor. I don't have to lecture this court on basic contract law, but there was never a meeting of the minds on this $5 million. It was never funded. The 1.1, almost immediately when my clients contacted their clients and said, hey, wait a minute, you were supposed to send us $5 million.
Wasn't that $5 million loan acknowledged by your client in their SEC filing and in other documents?
They filed what happened was they had a deadline to file the 8K, which contained many other items in there, but they were alerting their investors and their board that they had actually, this is a company that operates always chasing cash. So they had filed this 8K stating, we signed an agreement for this $5 million. We're going to be funded, plus we have other agreements that we're working on.
But they acknowledged that they received $1.15 million.
3 months after they initially filed the 8K saying we're going to get this $5 million, they had to amend the 8K, and they said the appellants defaulted on the $5 million loan. Instead, they sent us 1.15.
No, I think it was said the other way around. I think they said we received 1.15, and we don't think that they're going to give us more.
Well, they acknowledged that, but the language was that they defaulted on the $5 million loan.
We believe that they will be defaulting and they will not give us the rest.
Correct, because there were constant communications between the parties. If you also notice in the cause of action, it's Southern Israel and this gentleman, Amir. Amir was one of the individuals who negotiated, or was involved in the negotiation from very on, only to find out later on that Amir was the manager of this other entity, Beta 02, which appellants were trying to ram down the throat of my client because it would have been a big windfall. Subsequently, my clients did, as a means of trying to mitigate this, did agree to work with Beta 02 to try to resurrect their business. It ultimately proved unsuccessful. They were not able to get Beta 02 to the point where they were. But the Amir who negotiated
I mean, your opponent made this point, wasn't your remedy upon breach, upon their alleged breach, to just return the 1.5 mil?
That was offered. They said, don't return it because we're going to work something out. That was the whole point.
They want it now. Now they want their 1.5 million.
I understand, but Amir, on behalf of the appellant, entered into agreements, and they're attached in the record, where my clients actually did work. He signed work orders and acknowledged that my clients did $1 million worth of work, which they were told was going to be an offset of this 1.15. In essence,
all that was orally or in writing?
No, it's in writing. They're attached to the record are 2 work orders that were signed by the appellants that said, do the work. We're going to pay you
for better
work.
So do the work for better and
then offset it.
And this will be offset from this one.
Correct. And now appellant says, oh, wait a minute. It's a portfolio company. We have nothing to do with it. But Amir was an integral part of the entire negotiation from day one. He's a plaintiff in the action. He put money into the case. So that's why Judge Frank, when he wrote his decision, said there is sufficient evidence here that says there's triable issues of fact. This case was started, and then immediately the summary judgment motion was made. There's been no discovery. Counsel keeps saying that we waived our claims. We did not waive our claims. Judge Frank specifically said we didn't waive our claims because we sent letters, we sent emails, we sent text messages, we had phone calls, we had meetings. They were flying all over the world trying to negotiate what ultimately was going to happen.
Thank you, counsel. You set that forth very well in your brief. Thank you.
Your Honor, when he says that there were papers signed by the appellants that they owed the money, it's just not true. One of the appellants, Mr. Hasidim, signed on behalf of a portfolio company that was the subject of these negotiations. We've tried very hard, and I think succeeded, in cutting through a lot of this. You negotiated this and you said that, and all of that, because the fundamental point for our case is you've got to be able to lend money and then at the end of the loan term, get it back. And all of these negotiations and all of these discussions, they take place within the context of a private equity firm lending money to someone, setting the context for the relationship that's going to go forward. But all of that depends on, at the end of the day, a lender being able to recover the loan funds that they loaned.
Well, counsel, is that accurate? I mean, it takes place in the context of promising to lend a certain amount of money, never actually lending that amount of money, and then inserting other terms to it in terms of having to deal with this other company and bring this other company along.
There are no other terms. There's no mechanism for forcing anything. Right, there's a loan agreement. We loaned the $1.15 million. There was no power, and that's what we were trying to cut through. Is we loaned the money, the loan has come due. There may have been negotiations between parties through the process. There may have even been agreements between other entities. But at the end of the day, my client lent the money, and whether it's duress, whether it's breach of contract, the loan term is over. And if we can't collect on that $1.15 million at the end of the loan term, then the entire context is ruined, and people can't lend money and not be able to collect the money at the end of the term, or even to wade through all of the negotiations and all of the allegations and have to cut through all of that in order to just recover. When the money was loaned, they explicitly said 2 months after the money was loaned that the 1.15 was pursuant to the convertible loan agreement, and it's absolutely clear in their Form 8K, which is a federal filing. It's fraud if you lie on it, right? So they said it was a 1.15 million. They said it's subject to the same terms. The term has expired.
But did they know they were that company was going to try to force them to work with another company and bring along another company that was failing?
I'm not sure what that means, that they were trying to force them. They loaned money. They didn't have a gun that they could put to their head. All that they could do was say at the end of the loan term, we want our money back. There's no compulsion.
Well, they need the rest of the loan money to keep the company going. And so by withholding the rest of that loan money, they're not really able to keep the company going. But
and that's a breach of contract.
Thank you both. People versus Umar Ali. Please.
May it please the court, Samuel Steinbach Pratt from the Office of the Appellate Defender on behalf of Umar Ali. This is an unusual case where the plea and sentencing judge expressed on the record a desire to impose a lower sentence than she was legally able to do so because the prosecution wouldn't consent to it. This court has long spoken, as has the Court of Appeals, of the respect afforded to the sentencing judge when it is reviewing the excessiveness of a sentence. I think the transcript in this case is a red flag for the fact that the sentence might be excessive because the sentencing judge all but said that it was. This court should modestly reduce Mr. Ali's sentence to a term of 3 to 6 years, something the sentencing court could not do, but that this court is empowered to do.
Now, what would be the efficacy of that, though, counsel, given that his Bronx sentence, when his Bronx sentence is over, he's then eligible for parole?
So The current term is controlling the maximum of his aggregate sentence because they're all concurrent. And the length of the term is such that reducing his sentence, his maximum expiration date currently is in late April of 2026. Reducing his sentence would mean he would be released shortly, essentially, if you reduce it to a term of 3 to 6 years. And then he would be on a term of PRS because of the Bronx.
So he could potentially get out sooner. It's on the order of like half a year?
He could potentially get out sooner, but it is not likely, I think. This ties into what we talk about in our brief about his struggles with mental illness. In the PSI interview, he has extreme difficulty remembering even the names of his parents or the number of siblings he has. And I can tell you that his condition has pretty seriously deteriorated in docs to the point where it's been very difficult to even communicate with him. That's post-judgment, but I think it's important for this court to know. He is bluntly not doing well, and I think he would do much better in the community under supervision than he is currently able to do in docs, especially given the fallout from the work stoppage earlier this year. But again, I think under these unusual circumstances, given what the court expressed on the record, a small reduction is amply warranted. Unless the court has any further questions, I'll return on rebuttal. Thank you.
Thank you, Counsel.
Good afternoon, and may it please the court, Assistant District Attorney Max Bernstein for the people. While it's true generally that sentencing judges are afforded a certain amount of deference on appeal, that almost always happens in the case of a sentencing judge actually handing down sentence after a trial. The sentencing judge here took no part in the actual consideration of the sentence at issue because this was a plea bargain through which defendant was able to avoid facing trial on a much more serious robbery one charge, which the evidence, at least that we're privy to in the DA's office, was substantially strong and which he likely would have faced conviction. Had he gone to trial and been convicted on the robbery one count, he would have had a minimum sentence of 8 years. So significantly more exposure than he received here. Judge Pickle's comment during the sentencing proceedings, or during the plea proceedings, I should say, are better understood as a simple way of clarifying to the defendant who, throughout his...
So just so we go back to the robbery charge, we're talking about stealing $1,000 pants from Saks, right?
$3,000 worth of products, including the $1,000 pants, yes, with a knife, yeah.
Well, the knife wasn't used in the course of the robbery. They found it after he was apprehended,
So this did not come out because of the plea. We didn't reach this, but in point of fact, what actually happened is the knife came out during the struggle with the security officer when the security officer was attempting to stop the defendant from leaving with the property. So it didn't happen, I guess, in the actual course of removing the property, but it did happen in the course of the crime. So there was a strong robbery one claim here, and I think, frankly, defendant's plea only makes sense in the context of a conviction that the robbery one charge was at least plausible. And of course, the robbery one count was indicted by a grand jury. It survived review on motions. There was at least sufficient evidence, or legally sufficient evidence, to support a charge of robbery one, certainly. But I just want to clarify again, I think Judge Pickle's comments deserve to be understood within the context of normal proceedings within the TAP part of Supreme Court. His case had been lingering in TAP for over a year. He had considered this plea offer several times. He was finally down to Judge Pickle basically offering him a simple choice. Do you want this plea or do you want to go to trial? Those are what's on offer for you. And defendant, who apparently had a difficult time sitting through most court proceedings, including this plea, he interrupted the plea proceedings at least 2 or 3 times on the record, was evidently looking for yet another way to end run the process and was hoping that Judge Pickles would do him a favor and give him an even lower sentence than the people were prepared to offer. Judge Pickles' comment was simply a way to explain to defendant, I can't help you. Your options are take the pleas that's been offered or go to trial on the robbery one count. That's clearly the import of what she was saying, having stood in TAP many times myself. I know how difficult these pleas can be. It's very hard, understandably, for a defendant to accept responsibility and go to jail. That's obviously an enormous challenge. She was trying to explain to the defendant, look, these are your options. You have no other choice. Do you want to go to trial or do you want to accept the people's plea? I think it's passing unlikely that she was actually commenting on the appropriateness of the sentence, given that she knew very, very little about what actually had happened in this case. She heard about the case for the first time in the prior appearance just 2 weeks before, which was a TAP appearance. There was not extensive motion practice before her. She did not conduct hearings. She knew almost nothing about this case.
The statement was made during the plea proceedings, not during the sentencing proceedings, right?
It was made during the plea proceedings, yes, Judge.
Okay, thank you. Any other questions? Thank you, Counsel.
Thank you.
With respect to what Judge Pickles said, I just don't think that what respondent is representing is a plausible gloss, because she did say elsewhere in the record, you can take the plea or go to trial. She said that very clearly one or two other times. But what she said in the comment that we're talking about is when Mr. Ali asked for a shorter sentence, I can't do that. I wish I could, but I can't. If I had the power to do it, I would, but I can't. It's up to the prosecution. I don't think you can get much more explicit that Judge Pickles would have offered Mr. Ali a lower sentence if she were empowered to do so.
Can we interpret that as being that she is trying to get the defendant to understand that this is the offer you're being made right now, and you're not going to get another offer?
I don't think so, because
it's not within my power to give you another offer.
I mean, I think that's part of what she's saying is that, like, look, this is the offer on the table. And else, later on, this is from page 7 of the plea transcript. Later, she says, do you want to plead guilty? Otherwise, we're going to proceed. We're going to trial.
Counsel, what is the import of that with regard to our analysis of whether the sentence is excessive in any event?
Yeah, so this court and the Court of Appeals have talked about, this court exercises its own discretion, obviously, but also there is a certain amount of respect for the sentencing judge. And in 99% of cases, that is going to mean you look at the sentence that was actually imposed. This is the rare case, it's the only one I personally have seen, where the judge says on the record that they would like to offer a lower sentence but can't. I think that's unusual, I think it's noteworthy, and I think it warrants careful consideration of whether a modestly reduced sentence, not a huge reduction, would still serve the purposes of sentencing, especially given, again, Mr. Ali's struggles with mental illness. Thank you.
Thank you. Thank you both, counsel. People versus Rosser. Please.
Thank you, Your Honor. May it please the Court. Whitney Elliott of the Legal Aid Society for the Appellant. Especially given the circumstances from which Robin Rosser entered treatment, her accomplishments there were extraordinary. She completed 16 and a half months of residential treatment, became a role model for her peers, showed real insight and an authentic desire to overcome her addictions, had even started training to herself become a substance use counselor, and even started working as a patient navigator. She came very, very close to realizing the main goal of a diversion program, which is helping people develop the skills that are needed to start building a productive life in the community. We think that she should have been given that chance.
See, the court had before the previous failure to comply with a deferred sentence, correct?
Yes, that did happen, Your Honor.
And then the 16 months happened, which is commendable. But you think that that is sufficient for us to go against the very broad discretion given to courts who have to determine what to do in the violation of a plea agreement?
So, a couple responses, Your Honor. I think we do reject we don't think that there's, the court's discretion here is really constrained by the statute governing diversion programs, which require the court to consider, for example, the views of the substance use treatment provider. And I think most critically here, the extent to which graduated lesser sanctions could facilitate a defendant's successful completion of a treatment program.
Should we look at this in a vacuum, or should we also look at the totality of the circumstances? Meaning, she was already in a program, she absconded, she was rearrested, and instead of getting the 2 to 4 that she was told she would get if she violated that first program, she was again given a second program, and she was warned. If you, for any reason, do not complete, you're gonna get 2 to 4 years. And now, here we are. After she did 16 months or so in the program, she again violated the conditions of the agreement and used drugs again and lied to the court and lied to the police and lied at the hospital. And the court, looking at everything, said, that's it, you're not gonna get another break.
So a few things, Your Honor. I just wanna, in terms of, we welcome looking at the whole picture. At the time Ms. Rosser started treatment, she was 52 years old, had experienced decades of substance use and homelessness and untreated mental illness on the streets. She overcame extraordinary trauma from her childhood. And her own treatment provider was saying, we want her to come back. We understand that this relapse happened. She made a poor decision to try to cover it up by being dishonest. But that doesn't mean that she's incorrigible. That just means that she hasn't yet developed all the skills that she needs to live independently. But because of the 16 and a half months of success that she's had, we still think that she can succeed and overcome the thought patterns that led her to tell that lie. And even the MDC, Manhattan Drug Court caseworker, says, look, I understand, we recognize this dishonesty happened. My recommendation is just remand her for and extend her residential treatment for a month. What the court here did was really just reflexively, which I think just felt personally affronted by what Ms. Rosser did and didn't really implement this sort of statutory mandate, which is to consider graduated sanctions, which to the extent possible could facilitate a defendant's successful completion of a treatment program. She had completed 16 and a half months after coming from circumstances of extraordinary disadvantage. What she accomplished here was really incredible, and I think that's what her treatment provider was recognizing. That's what the MDC caseworker was recognizing. But the court really just sought to punish her because of her.
Counsel, you are conceding, though, that she did violate the terms of the plea agreement, right?
No, we're not. In terms of violating and that would authorize the court to sentence her, no.
Okay, so if you're not conceding that, is that claim preserved for our review?
No, no. Defense counsel did not specifically argue that under the operative terms of the plea agreement, a relapse and rule violation does not authorize the court to sentence her to incarceration. Defense counsel did not argue that, we acknowledge. But there are many appellate division cases, and we cite them, where courts have reached that kind of claim in the interest of justice. And here, in a very extensive oral colloquy, the court told Ms. Rosser, here's what's going to happen. Here are the terms. If you relapse, you could get more time. If you violate a rule, you could get more time in residential treatment. What the court said would allow the court to impose sentence was if you fail to complete the program. Ms. Rosser did not fail to complete her treatment provider was ready to take her back. Thank you.
Good afternoon, Your Honors. May it please the court. Peter Rienzi on behalf of the people. Your Honors, the court validly imposed the prison sentence called for in defendant's plea agreement. That sentence should not be set aside. As Justice Michael pointed out, defendant's arguments on appeal are unpreserved. It is clear that defendant violated the plea agreement and failed to complete the program.
But counsel, in looking at the violations, isn't that the violations that we're talking about kind of part and parcel of what comes with trying to overcome a drug addiction, a substance abuse problem?
Your Honor, yeah, there certainly is an argument for that. However, but they also are pretty straightforward violations of the program rules, leaving the program without permission, not coming back, taking drugs.
Your adversary said the program was willing to work with her.
Yes, that is not in dispute. No, but as the law requires, under the CPL, the judge did consider all those factors. The judge certainly considered, in addition to the prosecutor's recommendation, the defendant herself making various statements, admitting that she had violated the rules. The defense counsel, the program had written a letter that Justice Nunez said she had read before sentencing. All the big picture, as one of your honors mentioned, the entirety, the totality of the circumstances, all of that was considered by Justice Nunez in this case.
And it's discretionary for her to impose that sentence.
Yes, Your Honor, it is, exactly. And it was laid out in the written agreement that under any violation of the rules, that the sanction could be a change in the treatment program, it could be a termination of defendant's participation in the program, or it could be incarceration. And by failing to complete the program, she was at risk of all those potential sanctions, and the court, in its discretion, determined that that incarceration was the appropriate sanction. Again, considering the background, this was a reasonable exercise of discretion, most importantly being that this was the second time defendant had been entered into a program instead of automatically being sentenced to prison. This court should reject defendant's request that it reverse her convictions in the interest of justice. The circumstances that defendant has gone through, while certainly unfortunate, were all known to the sentencing court. Defendant, unfortunately, was not able to take advantage of the two opportunities that MDC provided her to pursue treatment instead of being sentenced to prison. And she has presented no reason on appeal to disturb that sentence now, 7 years after her release from prison. Finally, Your Honors, I just would say, if there are no further questions, I will rest on our brief, and we would say that other than the modification that we discuss in point 2 of our brief, where we consent to the modification.
Right, we noted that error, yeah, thank you.
Yes, so other than that modification, we ask that you affirm.
Thank you, Councilman.
Thank you.
So I guess just 2 quick points in rebuttal. In terms of preservation, there's no question that defense counsel preserved the argument that given all of the circumstances, Ms. Rosser should not have been terminated from treatment. In terms of the court's discretion, I just want to push back. I don't think that this decision is governed by a statute. In our reading of the statute, I don't think a court can say, yes, there are lesser sanctions that might facilitate your successful completion of a treatment program, but I'm just so affronted by what you have done, I'm not going to do it as a matter of my discretion. I think that kind of decision would violate the statute. I think that's the kind of decision that happened here, and I think that's why the court should give her the benefit of her plea agreement. Thank you.
Thank you both. Municipal Credit Union versus Kim Thomas. Please.
Good afternoon, Your Honors. May it please the court, Anthony Arfilosa on behalf of the appellant. The judgment and order of the Supreme Court should be reversed because the plaintiff's failure to take proceedings to enter judgment within 1 year of defendant Thomas's default mandated dismissal under CPLR 3215C. Under a long line of precedent from this court and the other departments, it's the filing
It's
of
not enough to file an RJI, we know that.
Correct. So it's the filing of a motion, Your Honor. And here it's just to belabor the point in terms of the timing. We have a May 2022 pleading default. We have a June 11, 2024 motion for a default judgment. So the burden shifted to the plaintiff to satisfy the sufficient cause standard, which is a 2-prong showing, as the court is aware. It's a reasonable excuse for the delay. They offered no excuse because they doubled down on this RJI theory.
Did they even argue sufficient cause below?
They did not. They doubled down. They said, we satisfied the 1 year deadline, so we don't have to demonstrate sufficient cause. So they've charted their course here. So for that reason, Your Honor, not to belabor the point on the 3215C thread, under Guebu, which Your Honor was on the panel, Justice Mendez was on the Guebu panel, under Shea, under a long line of 3215C cases, the outcome here is clear. Dismissal was mandatory.
Now, let me ask you this. Had this defendant, Mr. What's his name, Watkins, had he resided in the apartment, would the filing of the RJI had been sufficient for taking proceedings for a default judgment?
Let's take a step back. So Mr. Watkins was deceased, right? So just want to frame the hypothetical here. So there were no settlement conferences required here because he was deceased and the defendant, Executrix Thomas, did not reside at the property. So under 3408, that's not a home loan. You're not entitled to a settlement conference in every foreclosure action, so I would say no. Just to focus on the question, yes, hypothetically, where a borrower resides at the property at the time of the commencement of the action, that qualifies as a home loan under 3408, which triggers the settlement conference requirement. But let's not mix apples and oranges here. The filing of the RJI doesn't constitute taking of proceedings to move for a default within 1 year of the defendant's default.
But that is because the person was not residing at the premises.
Sure. I mean, our position, I believe, is consistent with the first, the third, and the fourth, is that this aberrant Second Department case is not the law, because it's the filing of a motion that satisfies 3215.
In all cases?
Correct. Even I'm standing before you saying here today, even if we had a living borrower who resided in the property, hence in that instance, there's no dispute that this was settlement conference eligible. The filing of an RJI doesn't constitute the taking of proceedings to enter judgment within 1 year of the default on the 3215C.
Well, counsel, just so that I'm understanding you correctly, the filing of the RJI seeking a settlement conference, you're saying would not qualify as taking a proceeding?
Correct. We're not taking proceedings to enter judgment within 1 year of the defendant's default. It's taking proceedings to enter judgment is the linchpin under 3215C.
Even if you need to have that settlement conference before you move for a default judgment?
Correct, because if you think about it, this is just a matter of statutory construction, right? We're asking ourselves, what did the legislature mean by the phrase taking proceedings to enter judgment within 1 year of the default on the 3215C? So we have to read the statute as a whole. If you look at another provision of the CPLR, 3408, that requires the filing of an RJI when you file the proof of service. Proof of service has to be done within 20 days of service. So by definition, you have one statute which requires you to do something before the defendant is in default. That, by definition, can't be the taking of proceedings to enter judgment within 1 year after the default. That creates an unnecessary tension between the two statutes. So the legislature could never have intended the filing of an RJI, even if it was required to constitute taking proceedings to enter a default, because by a separate act of the legislature, that has to be done before the defendant is in default.
But taking that a little further, once you file the RJI because you believe that you need a settlement conference before you move for a default judgment, that would be then we could consider that a reasonable excuse for not having moved within that 1 year to take proceedings.
Again, we're making sure we're dealing with hypotheticals here because it was apparent that the defendant was dead here. Just to take that thread, I would arguably say no because, again, the statute is clear. So the statute says it's within 1 year of the default. Settlement conferences, certainly settlement conferences in this case that happened 1 year after the default, certainly cannot excuse as a matter of common sense.
But you can't move for the default in certain cases unless you've had the settlement conference.
I would respectfully push back on that and say no, because if you read 3408N carefully, it says, motions submitted by plaintiff and defendant shall be held in abeyance by the court. So again, that doesn't restrain the plaintiff or defendant from filing a motion. It just says the court shall hold it in abeyance. They can delay adjudication until it gets released from the settlement conference part. That's 3408N, I believe.
So file a motion for a default even though you haven't completed all of the necessary components to obtain a default judgment?
Well, again, because, I guess it's just a matter of statutory construction. They're entitled, they have to prosecute the case. The court just doesn't have to adjudicate it. And quite frankly, I would say even from a policy standpoint, what's good for the goose is good for the gander. No one has read 3408 to excuse a borrower. They don't say, hey, borrower, you don't have to file an answer for the year, 2 years, however long it takes for this case to wind its way through the settlement conference. So why, again, as a matter of fundamental fairness, would we, I think it's respectfully a matter of judicial gloss. The statute doesn't say that. The statute says motions shall be held in abeyance. It doesn't prohibit the filing of the motion. I'll defer to rebuttal. Thank you.
Thank you.
Good afternoon again, Your Honors. Robert Yusko, McCabe, Weisberg, and Conway for the plaintiff respondent. It seems that counsel's focusing on the 3215C aspect of the appeal, so I'll address that.
What did you argue below with respect to that, 3215C?
Yes, so, Your Honors, we argued below that because the request for judicial intervention was filed seeking the scheduling of a 3408 settlement conferences, that did qualify as taking steps towards judgment. But I'd also argue making that argument opens it up to sufficient reason or a reasonable excuse for not proceeding to a default within a year.
I didn't see that in your papers below, and I didn't see that in your appellant's brief either.
Oh, Your Honor, I think the arguments themselves, when speaking to the seeking to have settlement conferences under CPLR 3408. That request was made within months of filing the complaint, and the motion for an order of reference was made within 45 days of the release from the settlement conference part. Make no mistake, there were no delays.
Right, but the question
or
is,
after.
did you argue that? Did you make any reference to the fact that this RJI for settlement conference was filed?
Well, yes, we certainly made the arguments that the RGI was filed for settlement conferences. That's in there. Our arguments focused on the fact that that should satisfy 3215C alone as taking steps towards judgment. However, those same arguments can and should be applicable to a reasonable excuse. They're right
But
in
did
the
you
paper.
argue that that was a reasonable excuse? Did you argue that?
Your Honor, we argued that we didn't have to have a reasonable excuse. But I think that the trial court and this court has the discretion to, if it believes that a reasonable excuse is required, what's in the papers is an attorney affirmation stating that request for settlement conference was made within months of the filing of the complaint. That request for judicial intervention sought settlement conferences. The courts encourage the parties to reach a settlement if possible, and oftentimes, if you don't seek to go to settlement conferences, people will come and they'll say, oh no, we actually reside at the property, this should go back to conferences.
How do you reconcile that with the case law that says that the filing of the RJI in and of itself is not sufficient for taking proceedings?
Your Honor, the different departments are split on it. So
Let's talk about this department.
In this department, I understand that this court does not believe it's taking proceedings to the entry of judgment. I respectfully disagree with that, but that doesn't necessarily matter here. What I would say is the cases cited by counsel in his briefs speaking to reasonable excuse, when it related to settlement conferences, it could be considered as a reasonable excuse. And there were no undue delays either before or after the settlement conferences. I think because the courts generally favor parties seeking to resolve settlement, especially in foreclosure actions if possible, and because generally speaking, a foreclosing plaintiff would like to either settle or check off the 3408 box.
Yeah.
So
But if you
as
don't
to
make
seek
the
a
argument
default
below,
judgment.
if you don't make the argument below, and then you don't make the argument in your briefs, can we then conclude that you have abandoned that argument, that you made out a reasonable excuse for not having taken proceedings within a year?
Especially when your argument is that you didn't need a reasonable excuse.
Your Honor, what I would say is, even for counsel to make legal arguments and to not be rebutted whatsoever, a court still sitting in its discretion can look at one side's arguments and say, you've either reached the standard or you haven't, notwithstanding any other opposition on the other side. For instance, in motions, for a summary judgment, if they're unopposed, courts can say, can step in and see if the prima facie case has been made or not on its own merits. And if the court is going to hold that a reasonable excuse wasn't provided, it has to look at its record before it does so. And on this record, I think it's very clear as a matter of record, it's not in dispute, that settlement conferences were sought early, order of reference was sought very quickly after it was released. And
we got that point, counsel. Let me ask you, before you sit down, about the service provision that the order of reference had. You didn't serve the West Fork, the owner of the equity of redemption, right? You didn't serve them as specified. Now, what what should be the consequences of that from your perspective, if any? In other words, they would say, you got to deny the summary judgment motion because we weren't properly served and we're the party in interest. What would you say to that?
What I would say is there is case law that if a notice of entry is not served on a party in interest, but that party in interest later annexes a copy of what should have been served with notice of its entry, then it is essentially admitting notice of entry by annexing papers. In this case, the party annexed papers to annexed the order of reference to its papers, referenced the order of references in its papers, was certainly on notice of the order of reference, and was not...
Was there a list pendants here too?
Yes, and they were not prejudiced in any way because they had an opportunity to oppose the motion for judgment of foreclosure and sale and to oppose the confirmation of the referee's computations, and that was considered by the trial court. So there's no prejudice, and based on that case law, as I said, I believe
Thank you, Counsel.
it should be upheld. Thank you, Your Honor.
Just very briefly, Your Honors.
Could you pick up that thread just while we're thinking about it?
So certainly, I mean, it seems to flow from this court's Rhea Pharmacy decision. It's just axiomatic that before you can enforce an order, you actually have to comply with the order. The trial court directs that the order of reference has to be served upon the owner of the equity of redemption, which no one disputes was Appellant West Fork. How can they obtain judgment when they themselves have not complied with that order?
But did they know at the time that they got the order that West
Fork's deed was a matter of
existed?
West Fork's deed was a matter of public record at that point in time. So West Fork's deed is recorded on August 2nd. That's record 292. The order of reference is entered on NYCEF on August 22nd. That's record 604. So
20 days later.
Constructive notice that our deed was of record. It
20
is
days
common
later.
practice in foreclosure to do an updated lien search to make sure you've joined all necessary parties, that all necessary parties have received notice. Just returning to the 3215C thread briefly, this is not a motion for summary judgment. There's no search the record power. Respectfully, Municipal's position turns the adversarial process on its ear. They charted their course in Supreme Court by saying we didn't have to show sufficient cause because we satisfied that deadline. That appeared to be a strategic mistake. They've made their bed. And with that, I'll rest. Thank you.
Thank you. Thank you both. Baton v. Pryor. Please.
May it please the court, Dalton Baton, appellant, pro se. Respondent contends that New York courts have consistently held that attorneys who represent themselves are not entitled to legal fees. However, there's no blanket rule or New York case law citing that pro se attorneys
Well, let's talk about, first of all, whether there's any reason to award attorneys' fees. Was there any frivolous conduct by the defendant that would justify attorneys' fees?
I don't think that's the issue here today. The court never ruled on the facts of the case. They just said that there was no.
Well, let me say that it is the issue today. So why don't you answer my question?
I think there is the record sufficient that the conduct was frivolous.
Why?
Respondent moved the court in 2016 to place funds into escrow account, and then essentially never moved the court ever again to ever recover those funds because respondent knew that the claim was frivolous.
Did the court ever direct respondent to move the funds?
Can you ask the question again?
Sure. Was there ever any direction to Mr. Pryor to move the escrow funds?
No.
Was it incumbent on Mr. Pryor to do anything about the escrow funds?
I think it's frivolous if you move a court to take an action and then you just sit on your hands for over 8 years and you don't take any more actions after the court orders for funds to be moved into an escrow account. I think essentially what the respondent did was an act of conversion. And if I did not become an attorney, those funds would probably still be sitting in that escrow account.
So now, if Mr. Pryor were to attend a hearing on the escrow funds or move or do something with it, wouldn't he need an attorney?
Not necessarily, but he was represented by Smith, Buss, and Jacobs. They're actually the ones who moved the court by email application to have the funds moved into escrow account.
I think the question is, he would have incurred some expense.
Mr. Pryor?
Yes.
I don't know what his expenses are.
But he would have, because he would need an attorney to make the application to the court to move the funds out of escrow.
That's possible, but Mr. Pryor was supposed to be the trustee of the trust. However, that did not end up happening because the court had its own concerns and appointed an independent trustee. So essentially, Mr. Pryor had retained counsel as trustee, as potential trustee, and the trust, whatever fees would have covered that counsel. That didn't happen. So I don't know if those counsel fees were encompassed in those fees that would have been directed from the trust or not.
How much was there in the trust fund?
In the entire
What was
trust?
the amount? Yeah.
About $130,000.
$130,000?
Yes, Your Honor.
Any other questions? Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, Jackie Aiello from Smith, Buss, and Jacobs for the respondent. The court started where I intended to start, which was the court does not even have to reach the question of whether or not a pro se attorney can recover their attorney's fees, because the immediate issue from my perspective is whether or not there would even be a basis for it, which is whether there was frivolous conduct or not. The motion court did not make any determination that there was frivolous conduct. There was nothing in the record that would even suggest that there was frivolous conduct.
Well, the 8-year delay can't constitute frivolous conduct?
The appellant could have also moved, for the motion that he made, he could have done years prior. So letting it sit is not frivolous conduct. Appellant had his right to do what he wanted to do when he wanted to do it.
So the respondent was okay, if he was okay leaving the funds to sit in escrow, he had no obligation to make a motion himself, right?
Yes, Your Honor, I agree. With there being no frivolous conduct, I don't think that the court even needs to address the other issue. But on that point, there is no case law, particularly under 130-1.1, in terms of whether that would encompass a pro se attorney. Appellant would like the court to look at the language very basically, which says any party or attorney can recover their attorney's fees. If we look at it in that way, it wouldn't even make sense because it says any party or attorney. It doesn't say any party that is an attorney or attorney. So that would, if we're looking at it based on what the words are as opposed to the legislative intent, that could mean that a party who is not an attorney could recover fees under 130-1.1. So appellant's view on the language of the statute, I think, is misguided. And finally, there, of course, as we discussed in the brief, the one case that appellant relies on is based on FOIL, which is a remedial statute. That case talks about real property law, lemon law, other remedial statutes, as opposed to disciplinary statutes like 130-1.1. There are no cases which suggest that a disciplinary statute would permit a pro se attorney to recover their attorney's fees.
But even if we disagree with you on that point, we don't need to reach it, do we, if we find no showing of frivolousness?
That's right, Your Honor.
Thank you.
Exactly. Thank you very much.
Thank you both. Rejulio, VFSP 787.
May I proceed?
Please.
Thank you. Good afternoon, Your Honors, and may it please the Court.
My name is Stephanie Arford, and I come before you today on behalf of Kennedy CMK LLP, representing the appellant in the present matter, FSP 787 7th LLC and 5th Street Properties LLC. It is my first time before this court, and I feel very humbled to be before your honors. Today we come before this court asking that the decision of the Honorable Shlomo Hagler, dated July 26th of 2024, be overturned. The main issue on this appeal is whether or not the trial court erred in its decision to deny appellant's motion for summary judgment.
You argue that, I guess, that the plaintiff's hearsay is the only evidence giving rise to an inference as to where she fell, but isn't there other evidence as well that is, and therefore, if there is other evidence, cannot we consider hearsay?
Your Honor, within a summary judgment motion, it would be possible for this court to consider hearsay evidence. However, when it comes to the penultimate determination on whether or not a trial court could viably find that there is a triable issue of fact, the answer is overwhelmingly no. Moving to the first point, that there is no evidence in this record that clearly can establish a recognizable defect on the subject premises that caused plaintiff to fall. In order to sustain an action of negligence, it's clear that a plaintiff has to establish two essential elements.
You've got Alfred, her husband's, the decedent's husband's testimony about what he did with her, and then also you have Ms. Butler's testimony. She was walking with the plaintiff when the plaintiff fell, allegedly. So why isn't that enough to provide some direct evidence, and therefore we can also consider the hearsay evidence of the decedent?
Your Honor, within the record, there have been two depositions that have been taken of non-party witnesses and also the party witness that Your Honor just referenced. There's been the deposition of Alfred Rejulio, and there has been a deposition of Hillary Butler. Both noticeably within those depositions, there has not been an identification of the subject defect. Within Alfred Rejulio's deposition, he was plainly asked from a photograph to identify the subject defect that gives rise to this cause of action, and he could not. When looking at a photograph of the subject premises, he could not determine where on that subject premises exactly the subject defect appeared.
But wasn't there also an expert who was shown the defective spot by the decedent?
Yes, Your Honor. Within Mr. Castle's report that is included within the record, there is photographs of an identification of a general area, and you can see within the record that there's the decedent is pointing to a general area. However, there's not a recognizable defect within that photograph. And moreover, the report that was given by Mr. Castle that was considered in the lower court's determination on whether or not summary judgment could be viably given in this instance, it's important to understand that Mr. Castle's report in and of itself, including the photograph that he used to create that report, is based on conclusory and speculation in and of itself, because there was never any determination from plaintiff herself of, yes, that is where the defect exists. So yes, there are photographs of the decedent pointing to a general area of the subject.
She's pointing to a slab, a square slab, which is approximately 1, 2, 3, 4 removed. 4 slabs is the 4th slab from the curb, and it's the 3rd slab from a tree. So couldn't we say that that's the one?
Not necessarily, Your Honor, and it's important to also understand that I understand that there is a photograph of the decedent pointing to a recognizable square, but however, the picture of her just pointing, Your Honor is able to determine that it was the X square over from the tree and the X square down from a certain location. However, there was no determined record from decedent of Your Honor exactly determining.
You mean like drawing an X on it, saying this is it, this is the one?
There was never any clear delineation of measurement from decedent of where this took place. Yes, there is a pointing of her to this subject defect alleged by her, but there is no direct examination or direct determination of this subject defect. And moreover, this creation of the report is based upon speculation because there is no clear defect that's been determined, and if we were to consider this case upon a trial posture, it's clear that also from Hillary Butler's deposition, she was there with decedent on the day, and even then, she is not able to look at a photograph of the subject premises and say, yes, that is where that happened. Ideally, if there was some sort of statement from the decedent that could pass hearsay determinations or hearsay preclusions, then this would be a different case, but that does not exist at this point in time.
Thank you, counsel. Oh, please.
No, that's okay.
Okay.
Thank you.
We'll have time in rebuttal, counsel.
Good afternoon, Your Honors. May it please the court. My name is Laura Gleicher on behalf of the respondent in this matter. The appellant is relying solely on an argument that states respondent cannot prove her case at the time of trial because of hearsay. The fact of the matter is, until we get to trial, we don't know what evidence is actually going to come in. It's respondent's position that the alleged hearsay statements fall within exceptions to the rule and will actually come in at trial. As to...
Are you not also arguing that there's other evidence raising triable questions of fact outside of hearsay evidence?
There certainly is, which is why the hearsay evidence can actually be considered. If we only had hearsay evidence, it would not be able to be considered. But the fact of the matter is, we have a non-party witness who was at the scene, who observed multiple pavers that were misleveled, and she saw that before the decedent actually tripped and fell.
The respondent's arguing that no one could point to the exact place of the raised tiles. Do we need the exact place, or can we use an inference to defeat a motion for summary judgment?
We can use an inference. We do not need to know the exact place. In fact, this court has held time and time again that you don't need the exact precise spot. In fact, one of the cases directly on point is Cherry v. Daytop Village, in which someone came out of a car, tripped and fell on multiple cracks in the area, didn't observe it before the incident occurred, and after she fell, she said, "That's where I fell." She couldn't exactly identify this specific crack as what caused me to fall, but she had the general area and vicinity, and that was sufficient to defeat the motion for summary judgment. It's also sufficient at the time of trial to establish the mechanism of the fall, the fact that there is a defect, and establish the location itself, which would get to a jury and could establish liability, which is very similar to this fact pattern. The fact is, we have defects in the vicinity of where this accident occurred. We have a non-party witness who identified all of the misleveled pavers. We have the husband of the decedent who arrived at the location. So we have the precise address, even if Ms. Butler couldn't recall the specific location of the building by actual physical address. So we have our location. We have our defect. We have the misleveled paver, which our expert, Mr. Cassell, went out. He measured the defect. He said that there's an administrative code violation. He also explained that there was soil...
Justice Hagler explicitly did not rely on your expert's testimony, right, or your expert's report. Didn't Justice Hagler say, "I'm not going to pay attention to what Mr. Castle said"?
Correct, but we are able to rely upon that at the time of trial to establish our case as well.
Potentially.
Potentially, and that's right. Until we actually get to the trial, we don't know what evidence is actually going to come in. At this stage, defendant had the prima facie burden, the burden to establish a prima facie entitlement to summary judgment, and they failed to do so, which is why the lower court decided the way it did. Thank you very much, Your Honors.
Thank you, counsel.
May I proceed? Thank you. It's important to note that in Judge Hagler's decision issued from the lower court that he relied on two cases in order to establish why appellants in this particular argument were not entitled to summary judgment. Both of the cases that were relied on in Judge Hagler's instance of his deliberation, they included other information that would not be subject to hearsay preclusion or extraneous evidence or speculation or inadmissible evidence that would not be able to be considered in trial. It included other evidence such as plaintiff's direct statements in and of themselves. And I think in the lower court's decision on this case, they took into account, yes, there are certain factual similarities between the two cases that were cited in the lower court, but there are other facts that would have determined that, yes, summary judgment was not ripe on those two prior cases. Here we are devoid of information that could possibly come into trial. There's an understanding that, yes, this has not gone into trial, and now there would not be an ability to determine what could or could not come in, but looking to the basic instincts of admissibility within New York State courts, there is no possible way that this report that was based on speculation and nothing but hearsay that would have came from decedent herself, that was communicated by other parties, non-party and plaintiff himself, there needs to be a determination that there is no possible way for this evidence to be considered. And yes, Judge Shlomo in the lower court did decide not to take into consideration this report because it is riddled with inadmissible information that could not possibly come into a consideration of this court. And so for that reason, and additionally for the reason that there is no solidified definition of where this recognizable defect that takes place on the subject premises is, we would rely on our papers, and we respectfully ask that this court overturn the lower court's decision. Thank you.
Thank you, counsel. Thank you both. Last up is Red Hill Biopharma v. Kuko.
Good afternoon, Your Honors. May I please the court? My name is Jenny Kim, representing Kuko, the defendant appellant in this case. I'd like to focus on, there are many numerous errors committed by the lower court, but I would like to focus today on 4 crucial errors. The first one, the lower court failed to find that there is an implied obligation for Red Hill to get opaganib approved by a regulatory agency. The lower court failed to consider that implied obligation, although it may not be expressed, is read
How
into the
could that
contract.
be implied and read into the contract when there was a specific disclaimer regarding getting those approvals?
Your Honor, thank you for that question. The specific disclaimer goes to the territory of South Korea. The agreement between the parties was that Red Hill would develop and approve the opaganib drug as a COVID-19 treatment in major jurisdictions such as the US, Europe, and England. And it also—
That is specifically written into the agreement?
It's not. It is so basic, so fundamentally contemplated by the parties that it need not be expressly stated in the contract. And the contract is just 2, the subscription agreement and the exclusive license agreement. There's no agreement to say Red Hill as a pharmaceutical company, a sophisticated pharmaceutical company whose business is in the development and getting the drug approved by a regulatory agency, to just that. Your Honors,
Counsel,
it is—
If it's so understood and so clear, why are all those, why are there more than 1, more than 2 disclaimers in various documents?
The disclaimer in the ELA, let's talk about the disclaimer in 9.3. 9.3 says, Red Hill is not going to guarantee that it will be approved in South Korea. Why does it say that? Because in South Korea, it was Kuko that was going to make the application with the approval that Red Hill obtained from US or Europe or England. That was the deal. That's why it is not spelled out in the ELA or the subscription
It doesn't say Korea, though, specifically. It says field of use,
in
correct?
the territory. The territory is defined as South Korea.
And in the territory will be successful. Okay.
There's also a disclaimer in 7.3 as well, right?
7.3 of the ELA?
Yes.
Your Honor, I am—
Well, don't worry about looking for it. You can go on with the other parts of your argument.
Okay, so so implied obligation, it is so fundamental, and you can see it in the parties' correspondence. Why would Red Hill publicize that it is trying to get approval in 11 countries, and it is actually seeking emergency use in certain countries, and telling Kuko the progress of these approvals, and Kuko asking incessantly, what is the status of opaganib in FDA, before EU, before English authorities, England authorities.
Wasn't this foreseeable? Isn't it foreseeable?
It was
that this-
foreseeable that, well, it wasn't foreseeable because of the representations made by Red Hill that it will soon be approved. There were numerous representations about how likely it's going to be positively approved by one of these agencies. But even if that were something that Kuko should be worried about, that it may not be approved once after all, it is the fundamental obligation to try to get it approved. That is the obligation of Red Hill. Let me tell you what Red Hill did not do. So the subscription agreement was signed in, I believe it was October 2020, 2021. And, sorry, October 2021. And in January, there was a EMA. EMA is the European authority, the FDA equivalent. They required a pivotal study. So pivotal, there are many words for a pivotal study, confirmatory study. It means that you need to do further studies on patients on wider scale to test the efficacy and safety of the drug. So EMA required pivotal study. By February 2022, all regulatory agencies required confirmatory study. So this has been admitted by Red Hill. Red Hill even told Kuko all regulatory agencies required confirmatory study. So then Kuko asked, so are you going to do the confirmatory study? And Red Hill said yes. Unbeknownst to Kuko, and we got this from the deposition of Mr. Rede, he said, in 2022, January 2022, there was no budget for a confirmatory study because confirmatory studies require more than a year to complete, and it requires tens of millions of dollars, which Red Hill did not have.
But
Now, at that point,
to counsel, but to get the confirmatory studies is not an explicit term in any of the contracts, is it?
it's not. But every regulatory agency required a confirmatory study. So in order to get it approved, you needed to do a confirmatory study. It's like ordering a plate. And you don't have to say, cook it before you bring it out.
Why did Kuko need for this particular drug to be approved in the United States and the European Union and in other places before your client could apply in Korea to get it approved?
That is the practice, and Red Hill is perfectly aware of that. In fact, it happens in Israel as well. You need the major jurisdictions to approve in order for other jurisdictions to follow suit.
So it's got to be approved in the United States, in the
Or
European
Europe.
Union, somewhere in Europe, before any other nation would look at this particular drug, at any drug.
It is standard practice, yes. And Red Hill knew this. And Red Hill,
So why not put that into the agreement, if that's the case, right? So you're at Kuko and you say, listen, I'm going to do it in Korea, but I want to make sure that you get this thing, you get the ball rolling in these other countries, and that you get approval in the United States, Europe, or wherever it is, big nation, so that I can get my thing done in Korea, so that I can get approval in Korea. But it's not in the contract.
that language is not in the contract because it was so specifically in the parties' contemplated arrangement.
So is there a merger clause? It's like whatever we discuss, it's got to be in writing, because if it's not in writing, it didn't happen?
Not in the ELA, but, Your Honor, there is plentiful of conversation between Kuko and Red Hill.
Yeah, but they have to be in the contract.
No, it doesn't have to be, because the law says if an obligation is so clearly contemplated by the parties that it is unnecessary to express it, and that is the law that this department issued in 2001 in 511 West versus Jennifer Realty. So it was so contemplated by the parties, and the correspondence. My time is up, but
Yeah, counsel, you have time in rebuttal to deal with this question and other questions as they arise. Thank you.
Your Honors, and may it please the Court, my name is Rebecca Schwartz from Haynes & Boone LLP, and I'm appearing on behalf of Plaintiff Respondent Red Hill Biopharma Limited. I do have planned remarks, but I'm going to address some of your comments first. I just would like to read the sentence of 9.3 after, that other than as stated in section 9.2, Red Hill makes no representations or warranty and specifically disclaims any guarantee that the registration and commercialization of the products that the licensed product intellectual property will be suitable for commercialization. So above and beyond the disclaimer regarding the territory, there was an explicit disclaimer that the intellectual property might not be suitable for commercialization. Otherwise, with respect to your question about the merger agreement, there was a specific provision that the agreement represented.
Counsel, and Kuko, being a sophisticated party, would have understood commercialization to mean have the necessary approvals from the those entities that they claim it was implied that they would get.
Yes, there's testimony in the record supporting that Kuko understood that commercialization meant as much. Otherwise, this is a simple breach of contract case between two highly sophisticated parties involving Kuko's blatant breach of two agreements, the subscription agreement and the exclusive license agreement. Under the subscription agreement, Kuko agreed to purchase shares in Red Hill valued at US $10 million to be paid in two tranches of $5 million each, and received Red Hill American Depository shares and a right of first offer for 3 drugs, including 2 developmental drugs and 1 FDA-approved drug. Under the exclusive license agreement, Red Hill granted Kuko an exclusive license for a developmental drug, opaganib, in South Korea in return for an upfront payment of $1.5 million. The exclusive license granted Kuko the exclusive license to commercialize opaganib in South Korea if it was ultimately approved by the KFDA.
And that commercialization is in South Korea.
Yes.
Right? How could they do that without getting without the drug being approved in other countries?
Respectfully, I think that there was evidence that under the unique circumstances of the COVID-19 pandemic, countries were making decisions based upon the availability of drugs, and there was some evidence that Kuko could have gotten this approved even without a prior approval from a different agency. Even if not, the parties accepted that risk, and Kuko accepted that risk because of the potential windfall if this drug ultimately was approved.
They ultimately negotiated for first offer for other nations in Asia too, right?
Sorry, Your Honor?
They also, Kuko negotiated to expand the territory to other nations in Asia.
Yes.
And they would get the first offer for the drug.
Yes, so on the same time that Kuko executed the exclusive license agreement, they executed an amendment to the subscription agreement extending their first offer to include additional territories. These were known and considered risks, and they knowingly made this agreement knowing that a further confirmatory study was required by all agencies, and they knowingly made that choice to continue to invest in opaganib, even though that they had a right of first offer for an FDA-approved drug because of the potential windfall during the COVID-19 pandemic of having a potential COVID-19 treatment, knowing that it might never be approved. It was only after Kuko breached the agreements and repeatedly reaffirmed its payment obligations that it ever raised any of these issues after Red Hill filed suit. It was only in the counterclaims that any of these issues were raised for the first time in a somewhat obvious effort to get out of its clear-cut payment obligations once it knew that it was no longer going to get the windfall that it had hoped for.
Right, they acknowledged the debt, didn't they, in the June 18th letter? Kuko acknowledged the debt.
Yes, in the letter agreement that they signed in June, after being aware of, it was aware when they signed the ELA that further confirmatory studies were needed. But when it signed the letter agreement, it was further aware, and it still signed the letter agreement, acknowledging its payment obligations, and again, not raising any of these issues at that time because they are fabricated. Because Kuko repeatedly acknowledged its failure to pay the amounts due and its counterclaims and defenses are flatly contradicted by all available evidence, summary judgment was appropriately granted in Red Hill's favor on all counts. If there are no further questions, I will rest on my brief.
Thank you.
Your Honors, there were several misrepresentations and concealment of material information from Kuko. That is clearly in the record, and lower court erred by ignoring those evidence or deciding for itself that it is a trial of fact. It is not. Your Honor, in the record, in February, the FDA issued a partial clinical hold. That means that you cannot do further studies on human beings with this drug for COVID-19 treatment. That was in February
Of 22.
of 2022. That information was withheld. It was not uploaded to the data room. It was not communicated to Kuko until May. This was after signing the ELA. So
When did you sign the letter agreement?
March 14th.
The letter agreement was signed in
The
March?
letter agreement was in June.
In June?
But even in June, Kuko didn't know that Red Hill was not going to do any confirmatory study. There is no opaganib as COVID-19 treatment today. Opaganib is now being developed as a diabetes drug or Ebola drug. Before COVID, it was being developed as a cancer drug. So maybe it suits everything. COVID-19, maybe Kuko should have done more studies and should have been more suspicious of this drug. But it was COVID-19. Everybody was strangling to get a drug to prevent lives from being lost. So Kuko may have been hasty, but it did not expect that Red Hill would stop developing COVID-19 drug in the middle of their contract and hide that critical information that the partial clinical hold will prevent Red Hill from conducting human studies. That information Kuko did not have. And the lower court should not have decided for itself whether that information was material to Kuko, and it reasonably relied on it. That issue should have been tried before a jury. Your Honor, the consideration here is opaganib, the COVID-19 drug, which Kuko does not have. Kuko, Your Honor, asked, is it a sophisticated company? It's a logistics company. It owns warehouses. It owns trucks.
We understand that from your brief, counsel, absolutely. Thank you.
And my
Thank
time
you
is
both.
Thank you.